Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, and you shall be heard. Now say the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. That works. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Shin. To my left, Justice Singh. We will be hearing, I'm going to say, 6 cases today. The rules are as they usually are with respect to most of the cases, which is to say 15 minutes per side and no rebuttal. Although the second and third cases are paired, and at the outset of that, I'll talk to counsel. I don't know if counsel is here in the room about the timing for that. We have read your briefs with some care and therefore know the facts. And if you want to, you can just launch into your argument, but it is your time to do with as you wish. The first matter we will hear is Commonwealth versus TAHATDIL. And we will hear first from Attorney LeClaire.
Good morning, and may it please the Court. Jessica LeClaire for Desmond TAHATDIL. Under the Second Amendment, there is no duty to flee one's home before bearing arms in self-defense. This case is clearly controlled by federal precedents, Bruin, McDonald, and Heller, and the law could not be more clear. The government cannot demand that a person flee.
Where does it say in any of those cases that there's no duty to retreat from a cohabitant in a home that couldn't be more clear? Because I have read them repeatedly, and I don't recall seeing anything like that.
What the Bruin and what those cases say is that the central component of the Second Amendment, the central component is the right to self-defense. And what Heller says is the right to self-defense is at its height when that occurs in the home. And so what we have here is a situation where Mr. TAHATDIL was exercising his right to self-defense. At least it comes within the scope of the Second Amendment because he was in his own home bearing a knife, for the purpose of self-defense. And so that falls clearly within the scope of what the Second Amendment protects. The case law speaks a great deal about firearms, the right to possess a firearm, but what the court has said is, what the Supreme Court has said is, the right is the right to self-defense.
And when does one have that right? Can he just, anytime someone walks towards him, shoot them? Or when is it self-defense? So
the scope of the Second Amendment right to self-defense is defined by how it was understood at the time of the founding. And at the time of the founding, what the universal rule was, there's no duty to retreat in one's home. The first aggressor doctrine did not protect...
From your spouse?
From anyone.
From your spouse?
Including a cohabitant.
My understanding is that the common law had a duty to retreat.
So what the case law says, and this is, if you look at People v. Tomlin cited in my brief, is that it was universal. There's no duty to retreat from the home.
What jurisdiction is that case from?
That's from New York, but it's a case from 1914 that surveys all of the authorities from that time. There's also United States v. Beard, United States v. Brown. They discuss what the common law right was at the time of the founding.
With respect to the duty of the retreat, those last 2 federal cases?
Yes.
Are they from the Supreme Court?
They're from the Supreme Court, those last 2 that I
mentioned. The Supreme Court has said that there is no duty to retreat in a self-defense situation in the home? As a matter of what, federal law?
As a matter of federal common law, that's correct.
What year were those cases?
I would have to... Let's see.
I find it sort of remarkable that there'd be no duty to retreat from your spouse coming at you with a gun. That seems very odd to me, doesn't it? To you? So you can just shoot your spouse? Because that's what's going to happen, of course.
Well, this is perhaps why I've discussed the policy reasons why the...
Not interested in that. We're not here to make policy. You can go to a legislature and get them to make some policy if you like.
So could you repeat your question, Your Honor?
My question is, a spouse doesn't have to retreat from their spouse coming at them in some way that they need self-defense. They can just shoot their spouse. And I said the reason I asked the question is because, of course, that's what's going to happen.
The rule is that there's no duty to retreat from a cohabitant. That rule, Massachusetts is one of the only states that has this rule.
How long has it had it? Because the cases refer to it as a common law rule.
But what the Supreme Court has said is that the Second Amendment right is defined by the common law.
And I'm saying that in Massachusetts, our cases, we were here actually before the United States was formed, and once the United States was formed, we were here before the Constitution was even adopted, and our cases refer to that duty to retreat as a common law duty.
They refer to the common law duty, but they don't specify until 1975 in Commonwealth v. Schaefer that the duty applies to the home from a person within the home.
Is there a case before that holding it doesn't?
No, I'm not aware of a case holding it doesn't. But even if it were only Massachusetts and were the common law of Massachusetts, what the Supreme Court has said is that the Second Amendment depends on a national tradition. Our national tradition is there's no duty to retreat from the home, and the identity of one's attacker doesn't determine whether there's a duty to retreat or not. And there's no logical reason why the duty to retreat should be different.
Well, there's a statute here getting rid of the duty to retreat for non-cohabitants. So that's the reason to distinguish them, because of a statute, right?
Yes, so after Commonwealth v. Schaefer held that the duty to retreat applies in the home, the legislature enacted the statute, Section 8A, that said there's no duty to retreat from an intruder. That left in place Schaefer's holding that there is a duty to retreat from a cohabitant. So that is the rule now, but that rule derives from 1975 Schaefer decision. It's not consistent with our nation's history and tradition, the national history and tradition. And in fact, it doesn't necessarily serve public safety. Flight does not necessarily decrease the danger to somebody who is in a cohabitant relationship with somebody who may abuse them. And in this case, we see this case did not involve a firearm. This case involves somebody attacked by somebody who was 8 inches taller, 60 pounds heavier, and 20 years younger. And the Second Amendment doesn't protect the right of a first aggressor. So the sky is not going to fall, I would suggest, if we adopt this rule and apply Bruin to this case. Other jurisdictions have this same rule. There's no reason to believe, there's no evidence. The Commonwealth was required to justify this law. There is no evidence that it would increase the harm to cohabitants. In fact, it may serve public safety to deter acts of domestic violence against from a stronger person to a more vulnerable victim. So because the court is here to apply the Second Amendment and not to serve policy, I think that Bruin does have clear application here. Again, the national tradition is there's no duty to retreat from the home. That doesn't mean that's not a free-for-all, you can do violence in your home. It means that when you have a belief that you are in imminent danger and that your life may be in imminent danger, and that belief is reasonable and that belief is subjectively authentic, that you can protect yourself before fleeing your home. So it simply preserves the right to self-defense that existed at common law. And I'll turn to Bruin again. The Commonwealth had the burden here. The Commonwealth had the burden to say that this right that the position that we adopt is inconsistent with our nation's historical tradition, because the Commonwealth did not muster any authority for its position that the duty to retreat applied to the
I
home.
take it you agree that self-defense can only be used when it's necessary.
I would agree with that,
Okay,
yes.
so why is it necessary if you can retreat? Isn't that the very definition of self-defense that we're talking about here? You can shoot the person before then leaving, but you could have left before. Doesn't sound like you need self-defense if you could have left.
Well, the first answer is that the instruction doesn't confine the duty to retreat to when it's unnecessary to use force in self-defense.
I'm asking you about the Second Amendment. You have agreed with me that self-defense may be used when necessary, but not when unnecessary. Okay, so I'm in a big hallway, it's wide open, and I'm standing here, and someone is coming at me with a paring knife, or I guess it's allegedly the other way around, with a bread knife. I can just, they're way down the hall, but they're coming at me. I know they are imminently intending to kill me. I can go down, it's a wide open hallway. I can just go down and out the door of the house. But instead, I stand my ground right there, and I shoot the person dead. Did I need to use self-defense?
I think that that would be a question for the jury. How fast is that person coming? And I think that in
Did
that...
I need to use, if I can, well, the current law is reasonable. They have to retreat if it's reasonable to do so. If it's
Right.
reasonable to do so, then they don't need self-defense, do they?
No, I think that that's true, that I think that
Okay.
in that situation,
So reasonable, a duty to retreat, if reasonable, is consistent with the First Amendment, Second Amendment, I mean.
it's consistent with the Second Amendment. However, if you are in your home, you don't have to retreat. So if that incident
The
occurred...
two people I've described both live there.
I'm sorry.
The two people I've described both live in the house. So you're saying the person doesn't have to retreat even if it's reasonable to do so, although you've also just said in such a circumstance they don't need to defend themselves.
Again, I think that that would, the Commonwealth can disprove self-defense if they can prove that the person who used deadly force did not have a reasonable belief that it was necessary.
I'm not asking about that. You said it had to be reasonable belief, okay?
Yes.
If they could reasonably get away,
Then the use of force was not necessary.
I couldn't agree with you more. And so the duty to retreat, if there's an avenue available, has to be taken.
I agree with that. Yes, Your Honor. I don't think we're trying to eliminate the duty to retreat completely. We're simply saying that if you are attacked in your own home and you have a reasonable belief that force is necessary, and you subjectively believe that force is necessary to save your own life, and in the words of the model instruction, Proposition 1 and 2, that that's the only means available to you, that you don't have some duty that precedes that to retreat from your own home. And what the jury was instructed in this case is that he did have a preceding duty. He had a duty to use all possible...
Reasonable.
If it's safe to do so.
Well-
So in what you just said, it would not be safe to retreat in that situation if the only means of defending oneself is deadly force.
I think this gets to a problem with the way that the instruction is worded, because what the case law says correctly is that you should retreat if you can retreat in safety. But that's not what the model instruction says. The model instruction is phrased to say the defendant must exhaust all reasonable alternatives. The term reasonable is not defined. Second, there's no temporal...
It says a person must retreat unless he reasonably believes that he cannot safely do so.
That's a comment on proposition number 3.
Right.
Proposition number 3 is the Commonwealth must prove the defendant did not exhaust all reasonable alternatives. But it doesn't say what I think would be a better way to capture this issue. The Commonwealth must prove the defendant could have retreated in complete safety and knew he could retreat in complete safety. On my reply brief, I've included in, I believe it's footnote 2, a number of formulations of this jury instruction that capture what the case law intends for the duty to retreat to mean, which is the Commonwealth must prove the defendant could retreat with complete safety and knew he could retreat with complete safety. But the instruction as worded, it doesn't say he could, it doesn't limit the duty to retreat to the moment that deadly force is used. So if somebody is arguing, if they're verbally arguing, the court says you have to use all reasonable means of retreat. It doesn't say that the duty arises at the moment that the force is employed.
So this goes a little bit into your second argument about the prosecutors. Can you address that, the prosecutors?
Yes. So what the prosecutor stressed through her questions of Mr. TAHATDIL and through her argument is he didn't leave the basement before the argument started. He didn't spend, 2 weeks after their argument.
Why wasn't that relevant to intent?
Your Honor, I wouldn't dispute that there may have been some relevance to those questions and to that argument, but there was no jury instruction telling the jury, these facts are admitted for the limited purpose of
Those aren't
intent.
facts. That's an argument. There are no facts admitted that you object to, right?
It's true. That's why I raised the ineffective. There's no objection, but the prosecutor lays the foundation for that argument by asking Mr. TAHATDIL, did you leave the basement before? Why did you slept in the basement? You could have slept upstairs that morning. You could have gone to the bathroom that morning. You could have avoided the basement.
How can those
altogether.
questions be improper? Your time is up, but I don't know if I assume there might be some more questions. I don't understand. Those questions are relevant to his intent. If you weren't kind of planning on having a confrontation, wouldn't you have slept upstairs? Wouldn't you have, and so forth?
And what I think would have been, I would point the court to Dawkins, cited in my brief, 189, A3rd, and 223. It discusses this issue. The jury should have been instructed that those facts in that argument was limited to the question of intent, not to the question of whether he could have retreated earlier in time, because the jury was permitted to find that if he failed to retreat from a verbal argument, the Commonwealth had disproven self-defense, and that was prejudicial to him.
More questions? No? Thank you very much.
Thank you,
Excellent argument. We will hear now from Attorney Lewis.
Good morning, Your Honors. May it please the Court. Sarah Lewis on behalf of the Commonwealth. We're asking this Court to affirm the lower court's denial of the defendant's motion for new trial. I think there's certainly an issue of waiver here as to all the claims raised by the defendant, but the motion judge, did reach the merits of the arguments, so I will begin there. I think it's important to center this argument on what the claim is. The defendant's challenge is to a jury instruction. The jury instruction being on the duty to retreat before using deadly force in self-defense. The defendant's arguing that it's that instruction that's inconsistent with the Second Amendment. It's unclear whether this is a facial or an as-applied challenge, but either way, it fails, and I would point to two primary reasons. First, the jury instruction on the duty to retreat before using deadly force in self-defense is not a law or a regulation that restricts gun ownership or possession under the Second Amendment. It's a limitation, as has already been discussed, on what is Massachusetts common law on the circumstances under which deadly force may lawfully be used. And I think that's an important distinction. Also, this instruction does not implicate arms under the Second Amendment necessarily. It may, but it doesn't all the time. I think the second point that's important is even as applied to this case, there's a question first of whether this kitchen paring knife is an arm protected by the Second Amendment, but assuming it is, and the defendant had a right to possess it to use for the purpose of self-defense, the instruction here did not unduly burden that right. It was a reasonable limitation on the right to use deadly force in self-defense. And here, that deadly force was used unlawfully, as the jury ultimately found, as fact finders after the jury was properly instructed by the judge. Massachusetts is not a stand-your-ground jurisdiction. The law in Massachusetts is always required, as established by common law, duty to retreat. This court spoke as much about this in Leonor Aguirre. I don't think I'm pronouncing that right. And I think that that case still stands despite Bruin.
Do you think the instruction that says the defendant has to use all means, all proper and reasonable means under the circumstances to avoid physical combat can encompass fleeing the home before the actual physical encounter begins?
I'm sorry, Your Honor, I didn't hear the beginning. Did you say, is there an
instruction that says the defendant has to use or attempt to use all proper and reasonable means under the circumstances to avoid physical combat? Does that mean that the defendant, or could that be read to mean that the defendant had to flee the home before the actual confrontation began?
I think it could, but I also think it depends on the circumstances of the case, and that's clear in the instruction. I'm going to quote the instruction given in this case as to the third proposition regarding the duty to retreat, which must be viewed, as the court instructs, in the circumstances of the case. So yes, the instruction is using all reasonable means. The Commonwealth must prove beyond a reasonable doubt, quote, the defendant did not use or attempt to use all proper and reasonable means under the circumstances to avoid physical combat before resorting to the use of deadly force. And that's volume 7, pages 75 to 78. But then just looking back to how the court instructed on that third proposition. And I will read the third proposition, again, is that the defendant did not use or attempt to use all proper or reasonable means under the circumstances. Whether a defendant used all reasonable means to avoid physical combat before resorting to the use of deadly force depends on all the circumstances, including the relative physical capabilities of the combatants, the weapons used, the availability of room to maneuver or escape from the area, and the location of the assault. So I think the fact that the location happened in the home is a consideration for the jury. But that clear instruction, and I'm reading from the instruction that was given in this case, was provided to the jury. And I think that is an important point when viewed within the Second Amendment. And the Commonwealth's position is that this claim falls outside the purview of the Second Amendment. But in any event, Heller allowed for reasonable limitations. And here, a duty to retreat is not an unduly burdensome limitation on the right to use deadly force in any circumstance whatsoever. And the judge clearly laid that out in the instructions in this case.
But your opponent argues that the instruction doesn't convey when the duty to retreat arises. And that's what I'm asking about.
Okay, and I'm sorry if I misunderstood the question. I would disagree with that. The judge here, and based on the model and jury instructions, which, by the way, the defendant did not seem to challenge below the actual construction of the instructions itself, and the motion judge noted that. But the instruction here is that the law does not permit retaliation or revenge, and that the proper exercise of self-defense arises from the necessity of the moment and ends when the necessity ends. And that is part of this instruction that was given to the jury about the moment where the retreat is at issue. The prosecutor's comments, if we're going to talk about the closing argument, about what the defendant did or did not do prior to when the necessity arose, as your honors have pointed out, were factual statements based on admissible evidence that hasn't been challenged. They weren't legal statements about the duty to retreat when the necessity arose. It was about the defendant's intent and creating a full picture of, for the jury, of the circumstances of this case, both preceding the necessity and the necessity itself when that arose. If your honors have no further questions, I would ask the court to affirm the motion judge's denial of the defendant's motion.
Thank you very much.
Thank you,
Another
Your Honor.
excellent argument. Very, very interesting case.
Thank you.
It is submitted. So we have two cases here, and oddly, the first one, at least in the order this is listed, is an issue that comes sort of in the middle of the second one. So, and I don't know, obviously it's two arguments, and if, and so formally it would be 15 minutes aside on each. I'm going to propose that we argue them together. Of course, you're the appellee in the second one and the appellant in the first one. So maybe if we get to that issue at the end, we'll, of course, you'll be arguing. Maybe you can just do it at the end, maybe do 5 minutes on that, and then you can get back up and do the appellee thing. So maybe a total of 15, 20 minutes aside. Do you think you can do it in that? I don't want to, it's your case, so I don't want to.
That's good.
Okay, work for you too? All right. Then with your assent, we will do that. The clock will be set to 20 minutes. We will hear next the two paired cases, number 25607 and number 25347, both of which are captioned Commonwealth versus Hayes. And we will hear first from Attorney DeMaio.
May it please the court, Christopher DeMaio for Michael Hayes. So there are four issues that we've raised on appeal. The fourth one, as the court noted, sort of overlaps with the Commonwealth's appeal. I'll just take them in order, starting with the sufficiency on the intimidation. So Exhibit 20, which is at page 155 of the appendix, was the basis for one of the intimidation convictions for which Mr. Hayes received 7 to 9 years in prison, which was later reduced to 5 or 6 years. We're submitting that that particular exhibit can only be punished if it falls into constitutionally unprotected speech, and the only plausible category of constitutionally unprotected speech that I can see here is that it's a true threat. Exhibit 20, you could say many things of it. It's offensive, it's juvenile, it's vulgar. What I don't think you can say is that a reasonable person would take it as a serious expression of an intent to do violence on the recipient here, and that is the standard in the Virginia v. Black case. And that's really the gist of the argument. And I don't think it's any different because this was brought under 13B as an intimidation charge. The same First Amendment restrictions apply. And the SJC said in the Welch case that this court, in fact, has an affirmative duty to interpret any criminal statute that touches on First Amendment and communications so as to not restrict protected speech.
What about the fact that it also constitutes harassment?
Well, I disagree with that. It constitutes harassment as well. I think all of it was brought as a 13B. It's a witness intimidation is the only charge that came out of this. But I'm arguing generally whether it's harassment, intimidation. If it relates to communications, then it falls under the ambit of the First Amendment, then it can't be punished unless it falls into one of these discrete categories of unprotected speech. Now, there's lots of harassment that involves non-communication, where you're, driving outside somebody's house or standing around their workplace, and that can certainly be punished because there's not really a First Amendment.
If you're right that that it has to be a true threat, and the way 258E has been treated suggests that might be right. How do you distinguish Commonwealth versus Joe, the 2001 case where a flyer was hung up in a school that didn't contain explicit words of threat, but was treated as a punishable act?
Well, the first thing that comes to mind is that 2001 is before Virginia v. Black, which was 2003, which is sort of the watershed moment, I think, for the true threats line of cases. That's the first one.
Yes, but this is a true threat. That didn't change the definition of true threat.
Well, I think so.
You think it changed the definition of true threat?
Oh, I'm sorry. I thought you were talking about.
No, Virginia v. Black.
I'm sorry. Did Virginia v. Black change?
I don't think it changed the definition of true threat.
No, but it is the. I don't know that prior to Virginia v. Black there was that enunciation of true threat that I just gave you, which is about a reasonable person taking what was heard as a serious expression of an intent to do violence. I think before that you had broader language, and it was narrowing. To answer your question about the flyers, though, also, I think that was libel. If you're putting in public, it's libel, which is another category of unprotected speech. I'm not saying
They don't say that. They say it's a true threat. The term true threat has been adopted to help distinguish between words that literally threaten but have an expressive purpose, such as political hyperbole, and words that are intended to place the target of the threat in fear, whether the threat is veiled or explicit. And then they say this was intended to get back at the victim by placing her in fear that she might suffer some sexual harm or wind up among the missing.
Well, if that's the case, I don't recall the exact details of what he wrote in the flyer, but if it's actually putting her in fear, then that kind of coincides with the language about a serious expression of intent to do violence. That might have been a stretch.
The jury is not actually instructed that way, correct?
They were not instructed, and I didn't.
And no one asked for them to be instructed that way.
No.
And you say this is a sufficiency argument. So
Yes.
are we to decide whether any reasonable juror could have found this to be a true threat, or are we deciding whether this is a true threat?
You're deciding whether any reasonable juror could have found this was a true threat.
Okay.
Yes. I didn't make an issue of the jury instructions got a bit muddled because Mr. Hayes, who was obviously pro se, was informed there's this new Counterman case, and you may have read it. There was some back and forth about it, and he objected to some instructions which might have arguably been helpful for him. So that wasn't the clearest. I'm just arguing that on the four corners of this.
So if a reasonable juror could find that drawing a swastika in the middle of someone's forehead is a true threat, then the evidence would be sufficient, right?
That's true. I don't think it is, and I think I've read a lot of true threats cases, and I mean there's thousands of them, but I will just say in general they have a more explicit threat of violence. I hope you die. I mean there's a whole continuum of clearly Mr. Hayes said some threats. He said I'm going to cut your husband's head off. All right, that's one extreme, and then there's it would be a shame if something happened to your children, and then. I wish you died, and then it becomes vaguer and harder to tell as you go along, and I submit that as a matter of law, this is far enough on the innocent end of the continuum.
Well, is the swastika analogous to a burning cross?
Well, I don't, and in this context, I mean, it's just kind of weird that Charles Manson, swastika on the forehead, I don't know what it was supposed to mean, but even if it were, I mean, burning crosses, what could be more alarming? And yet in the Virginia v. Black case, which was about burning crosses, they said you cannot say it's per se intent to intimidate. I mean, the First Amendment law is full of all kinds of offensive speech. It's all about Nazi.
Swastika on the forehead, which you mentioned Charles Manson. That's the only place I've ever seen that before. I don't know if that's talked about in the record at all, but it is the only place I've ever seen it before. Swastika is a very threatening symbol, and there's personal information suggesting that somehow the sender has some access to something personal about the person. I don't know if I don't know if doxing has a definition whether, this isn't exactly a photo of the home being posted on Facebook, but it is the person knowing it. It
That's
seems
true.
pretty close to me. I don't know.
I mean, it would be alarming, I think, for anyone to get a copy of their driver's license in the mail, regardless of the abuse and the swastikas, but the standard isn't alarming, it isn't annoying. I submit the standard is the one I gave from Virginia v. Black. But if there are no more questions on that, I'll move on to. I'll talk briefly about the authentication and proof beyond a reasonable doubt versus proof by preponderance of the evidence. Now, I have to admit at the outset we have a slight uphill battle here because there's a case, this court's case called Alden, which is similar. I'm going to submit that it's distinguishable and that our case is worse, but I think it's an interesting issue. It's one that Mr. Hayes, pro se, put his finger on, and I think his objection was really spot on, because you have here a case where in order to prove him guilty of most all of these charges, the Commonwealth had to prove beyond a reasonable doubt that he authored certain emails. So that being the case, I would submit that the authentication instruction that judges normally and properly give in a lot of cases didn't do anything here. It did not advance the analysis, and it can only be confusing for a jury to hear the same evidence have two different standards applied, which is what happened here, despite the presumption that juries are supposed to understand instructions. That I'd submit that presumption fails when it's very confusing. This is not a case like Purdy, which the judge talked about. Purdy is just a regular authentication case. I think it was like human trafficking or running a house of prostitution. You want to put in some text as circumstantial evidence that the defendant really was, he was texting some girls and that if he had actually authored them, that would prove that he was engaging in human trafficking. So there's a very clear distinction in that case between preponderance of the evidence that he wrote these texts versus beyond a reasonable doubt as to whatever the elements are of human trafficking. You don't have that at all, and that makes a lot of sense. And 95% of the time or more, authentication instructions are not confusing, and they make a lot of sense because there's a clear distinction. But here, it's the exact same evidence. It's the same text. So.
There's nothing in the instruction that was actually wrong, right?
Well, all right, I said a moment ago I was going to distinguish this from Alden, and I think that's part of it.
What case are you saying? Alden? Is that the case you're saying? Couldn't hear you.
Yeah, ALDEN. It's a 2018 case. And the Alden case also, it seems to me this isn't the first time I've seen this. It seems there's some misunderstanding because Judge Bloomer here seemed to think I've got to do this or this. And if you read the Alden case, they actually said, this is kind of confusing. It would have been better if the judge had spoken more about beyond a reasonable doubt and not preponderance. But he gave a very clear instruction, which is in the footnote of that Alden case, and we're not going to reverse. But Alden does not in any way countenance doing what the judge here giving this instruction. And then,
but my question, so is there anything in the instruction that was legally incorrect? I grant you it's confusing. I think in part that's because the law in this area is confusing. But is there anything that was legally incorrect?
well, I think this is at pages 11 and 12. All right, so the problem is he says parts that are clearly right and then parts which are ambiguous. So
which parts
the
are
burden,
wrong?
all right, this is page 11 and 12 of the July 26th.
July 26th.
The burden is always on the government to prove the charge beyond a reasonable doubt, not by a preponderance of the evidence. That's good. Then he continues on. That standard, preponderance of the evidence, only applies to whether you were satisfied that the defendant, more likely than not, or it was more probably true than not, that he sent or authored those emails. Well, that's wrong. At best, it's confusing, and I would submit that's just wrong because that's part of the element of the charge.
I mean, first the jury has to determine by preponderance whether the defendant was the author, and then they have to consider it as an element of the offense beyond a reasonable doubt. I mean, it's very confusing. I grant you that, but I don't see where it's wrong.
Well, I think the second sentence I just read is wrong. That standard preponderance only applies to whether you're satisfied that the defendant more likely than not, or more probably true than not, sent or authored those emails. He's talking, I think, there about the preliminary authentication, but that's just, I would submit that's wrong on the face of it. And to distinguish this case from Alden, there's sort of I didn't argue this in the brief as a abridgment of Mr. Hayes' right to give a closing, but it kind of overlaps with that because he says when Mr. Hayes first raised this issue, the judge says, he asked the judge, can I explain to the jury what the elements they have to find me guilty are? Okay, and the judge says, sure, and he says, okay, that fixes the problem. But then the judge goes on to say, if you get up and, he says, if you get up and you say that you have to find that I authored the emails or the electronic communications beyond a reasonable doubt, I'll stop you and I'll say, Mr. Hayes, that's not right. Okay, you don't want me to do that. And then he said a similar thing again. Let's see. Oh yeah, at the end, when the judge answered the jury's question, another distinction with Alden, I don't think Alden had a question on the specific point that the jury raised here. They were clearly confused. So they asked this question, the judge answers it, and Mr. Hayes says, I'm confused, I disagree. I think you have to say that in order to find the defendant guilty beyond a reasonable doubt, that the defendant authored those emails or sent those emails beyond a reasonable doubt, and the court says, no, that's not the case law. So why is that not the case law? I mean,
do you think the judge is saying, that's interesting, I hadn't focused on that the judge might actually have thought the wrong thing, not just instructed, I mean, because
hard to tell.
I think the instruction is legally accurate because of these cases saying that you have to do this. I'm not sure why you have to be instructed. Was there instruction about any other evidence that needed to be authenticated, or the only evidence was the?
I don't think there was any other. And when he gave it, he was referencing emails, so it was the same body of evidence, I think.
All right. So let me ask you this. Do you think the reason he said that's not a right instruction is because identity of the author is merely implicit in what we would ordinarily call the elements of this offense, right? The elements include that the defendant sent a communication, right? But we wouldn't ordinarily call it an element that it was him. It's just built into the first element.
I understand that, and I'm not sure that's
I'm not saying that makes it okay or not okay.
No, I understand. I think that's a bit subtle for I mean, the distinction between authentication and proof of his identity is subtle enough. Maybe you can make it very clear to a jury if you have a very clear instruction like the one in the Alden case, which was clearer. But yeah, I think that may be true. Although I'm not sure it's true across the board. There are a lot of charges here, and some of them might have explicitly called for authorship. All right.
So it's interesting to me the jury question pertained only to the charges of the harassment prevention order violation.
That's true.
And you say this is structural error. I'm really having trouble seeing how that could be when an instruction omits an element altogether or imposes a mandatory presumption incorrectly. We review that for harmless error, it's not structural error.
Well, that's my argument based
I understand. Let's assume the standard is harmless error.
Sure.
I mean, you would agree that if evidence is overwhelming, it's so overwhelming it could be harmless error, correct?
Some errors are harmless.
I mean, so for instance, it seems to me that from the defendant's closing, that he more or less was conceding that he sent the mailing with the swastika mailing.
Sure.
So would you agree the error would be harmless as to that conviction?
Well, I mean, his closing also was made, I believe the judge gave part of the instructions before the closing, so
right, but
arguably.
If the standard is harmless error, it is really difficult, based on the materials before us, to see as to which convictions the error may or may not have been harmless.
If it's harmless beyond a reasonable doubt, it's a very high standard. So I understand that, and it may be that the court feels that it has to parse out. I argued it with a broad brush because he's talking about authorship, and they all, to some degree, involve authorship, except for the one about a phone call. But yes, it may be that the court has to parse out that the evidence was stronger here, and that was not harmless beyond a reasonable doubt, and it was less harm here because of concessions he made or whatever. I'm not going to have time to talk about the warrant, but I'll just say that in general, I think this, Mr. Hayes' beef here about the search is that he thinks it's not so much that the search was done, but the way it was done is sort of an end run around the particularity clause. All right, so if the detectives had asked for a warrant to search A, B, C, and D and had done that, that's fine, but they asked for a warrant to search for A and B, and they searched A, B, C, and D and said, well, C and D are reasonably encompassed within A and B. You know, we're looking for emails.
My understanding, and this wasn't, I'll ask opposing counsel as well. The warrant had asked that the phone be allowed to be forensically examined to obtain evidence including, and D is data related to the creation, use, or purchase of password manipulation software, virus, malware, and related software that could be utilized to infiltrate or compromise the email and or social media accounts of the victim. Do you agree that that's what the warrant authorized?
Yes.
Okay, so now what I'm trying to figure out is, and I don't quite have this, and you're out of time, but I need you to answer this question. They then looked on the phone at every photograph, I take it.
Yes.
Now, you talk about apps, but they used some backdoor thing, so they didn't click on an app. They got, apparently, I have no idea how this works. But even if they clicked on the app, they say, well, we have to look for screenshots. Is there a way other than opening every photograph to look at screenshots? And then same question for documents. And then final question is there something different about the search of the laptop that revealed this doctored photo, or is it again a search of a photo that could have been a...
To answer the last question first, I don't know that there's any difference in the way that I think they use the Celebrite machine on all of it. I don't know that once you're searching for a particular photo, there's a way to, maybe there's AI now, and you can do it without looking at every single one. But Mr. Hayes's beef, I guess, is that they were searching for photos at all without putting it in. And I get that last bullet point is a bit broader, where it talks about data. But you know, if you wanna search for emails and photos, and say you want to search for emails and photos, and not say, I just want to search for emails, and then search for photos and say, well, he could have taken a screenshot of his email. It's sort of an end run around the whole point of this is to have the magistrate deciding the list is appropriate, not having police do it on the fly.
Okay, thank you. We'll hear from you again at some point here. And now we'll hear from Attorney Lee.
May it please the Court. Special ADA Chi Lee from Middlesex on behalf of the Commonwealth. The defendant's witness intimidation against one single witness from Texas is consistent with the First Amendment for 3 reasons: true threat, speech integral to criminal conduct, and in any event, it passes strict scrutiny. A swastika is a symbol of hatred, genocide. It represents hate. It is similar, as Justice Singh pointed out, similar to Burning Cross. In Virginia versus Black, Justice O'Connor never said Burning Cross is not a hateful or threatening symbol. Indeed, in that case, Justice O'Connor actually spent quite some length explaining the history of Burning Cross and how dangerous, how threatening it is to a certain group of people in the United States. Same thing with swastika, especially in the current climate. With the swastika drew on the witness's forehead, and before this letter, there was a private investigator approached the witness, the victim witness in this case. This would represent a true threat. The victim here knew the symbol of genocide and hatred could lead potential dangerous outcome, and she testified she was scared and angry. In addition, this is also speech integral to criminal conduct because the wanted part of the letter, she was wanted for made-up crimes the defendant wrote on, that entice others to harass.
I've dealt with the First Amendment for a long time, and this is the first time I heard there's a category called, what is it, integral to criminal conduct?
Speech integral to criminal conduct.
And I see it was used in an opinion of the Supreme Court, but not the SJC. I'm just not aware that that's a category of unprotected speech. I'm not sure how broad it could be. I mean, I suppose if I say, listen, Bill, go kill him. I'm not threatening anybody. I've said go kill him. That's the way I committed the crime. People talk about things like speech acts and things to get around the fact that it's a verbal formulation. But this integral to a criminal thing sounds like it would cover any discussion of any kind, anywhere, that might be about a crime. And I'm just not aware that that the First Amendment covers that broad swath. I know about libel, I know about obscenity, I know about fighting words, I know about true threats. You see what I mean?
Yes, Your Honor, and your point, your question actually, it was the purpose of speech integral to criminal conduct. It was the basis where we have solicitation crimes. And encountment, it was one of the listed categories that's protected under the First Amendment. It has a long history within the Supreme Court jurisprudence under the First Amendment. And in this case, the key is not that the speech itself is integral to criminal conduct. The point is, if a defendant uses speech to lead to a criminal conduct, for example, in this case, the wanted part where the victim was wanted for made-up crimes, that would lead to others, that would entice others to harass or commit assault and battery or kidnap the victim.
That might be why it's a true threat.
Yes, Your Honor.
But I don't know, speech integral.
And if you look at State v. Hill out of New Jersey, that is also a part of witness intimidation statute where the Supreme Court of New Jersey in there recognized witness intimidation is a type of speech integral to criminal conduct that's consistent with First Amendment. And in any event, the Commonwealth had compelling interest to protect witnesses within a judicial process. In this case, what the defendant did wrong.
I think you're going a little far there.
Yes. But just really to cover.
Narrowly tailored to serve a compelling government interest, and presumably protection of people from crime is compelling too. So I guess there's no protected speech in criminal cases, but I'm pretty sure that's wrong.
No, Your Honor, because the key is the narrowly tailored test. In this case, what the defendant did wrong was he sent a letter to the witness victim here. If all he did is to wrote or drew a swastika at his cell, that would be perfectly fine. It's not criminal. What's wrong is he sent a threatening letter to the witness here.
I don't think that hate speech is unprotected, but maybe it's integral to criminal conduct. I'm pretty sure we don't have an exception for hate speech.
Exactly.
But if someone sprays a swastika on my front door, right, a lot of people would say, well, arrest him. There's a compelling government interest in stopping this. And I just don't think that's...
No, in that case, in your example, I think it's true threat because there's a criminal conduct combined together. But in the event, as Your Honor discussed with my friend on the other side, this is true threat where swastika has a profound meaning, not in the United States only, but in the world that represents a genocide. Moving to jury instruction, this instruction, as Justice Shin pointed out, this is legally correct. And this is the same instruction this court upheld in Abraham in 2014, Alden in 2018, and in Middleton in 2022. What's confusing here is I don't really understand why the jury needs to be instructed on a gatekeeper function the judge performed under Rule 104B. And after Purdy itself never required judges to give this preponderance instruction. It was somehow the case law, and from this court and the guide to evidence notes that encouraged and required the judges to get that 104B instruction. So I would encourage this court to maybe clarify this confusing part and really just keep that gatekeeper function to the judge itself.
Then why shouldn't we, I mean, I don't think it's about the gatekeeper function, but so we should reverse. You're conceding there's a problem with the instruction.
No. What I'm saying is this is legally correct, but to help the jury in future cases,
Well, isn't a confusing instruction problematic also on an element of the offense? I mean, isn't there a risk that, and then when they ask the question, they're told the same exact words that are confusing?
unfortunately, that's the nature of the legal world and jury instructions, because we cannot make every single complex legal element to be as clear as possible to a layman. What the judge did here, that's approved by this court 3 times, was the proper and legally correct instruction. The only way we can move forward is to how to make this less confusing and maybe better help the jury in deciding this type of cases.
Any of those cases, did the question of authentication merge with the elements of the crime as they did here?
Not exactly the same.
I mean, it's not as confusing if it's not essentially subsumed within the element of the crime, right? So the problem here is that they necessarily had to find he was the author, that he sent the communications beyond a reasonable doubt, right? That he contacted her beyond a reasonable doubt. So then you have these 2 standards that seem to conflict.
Right. However, the bottom line still is the instruction was legally correct. The jury has to find there's preponderance evidence the defendant authored communication for them to consider the
Should
evidence
we,
at
if we
all.
were going to try to fix this problem, and I don't know, I'm pretty sure we can't overrule a prior panel decision, although we might distinguish it. Why is this instruction given? Every piece of evidence has to be authenticated. Everything that comes in, the jury has to find by a preponderance of the evidence that it is what it purports to be. Otherwise, they shouldn't consider it. But we don't give that instruction except for some reason about electronic evidence.
It is interesting to see how some evidence will come in with this gatekeeper or preliminary findings. Authentication is one of them in digital communication. Business record is another example. I personally do not understand why the jury need to find find a preliminary question finding made by the judge as a legal question.
The
under
judge
104.
only finds that a jury could find by a preponderance of the evidence.
Exactly.
That doesn't mean that, and although this is a criminal case, there are cases saying the implication of that is that properly authenticated items nonetheless have to be found by the jury to be what they're claimed to be by a preponderance of the evidence. So they do that. They're supposed to do that, but we only instruct about maybe there's 2 things. I don't know. But maybe.
Yes, but 104B is a legal question for the judge to decide, and the judge did decide in this case there was preponderance evidence to show the defendant was the author of these communications, and the jury instruction were correct and pointed out to the jury they need to find by preponderance the defendant authored the communication, and then they can use the evidence to decide whether the Commonwealth proved the elements of the crime beyond a reasonable doubt. That's the correct standard. There's no error here. As to the search warrant scopes here, about the search of the photos, whether the police use Celebrite or Gray Key, which is the 2 dominant softwares out there, the police cannot go to each categories of apps. The only way for them to do is the categories of information. So here, the only way to go to the screenshots to show the communication history is to click the photos. And that photo search is justified under Snow, where the SJC had determined or held that if you have probable cause to search communication, which the police did here, they could search the photos because the SJC decided that people take screenshots of the communications, and that's what allowed
Is
the
there a
search here.
holding of the SJC that says if you're looking for a document that might be on a screenshot, that you can look through every photo in a phone? Because we have strong opinions. Justice Alito wrote one for the Supreme Court, and our SJC has one as well, that say, geez, rummaging through a phone is like going through everything in a person's life, and it has to be so narrowly and carefully done. And if you look at every picture on a phone, I mean, I have pictures. My daughter is 12 now. I have pictures saved on my phone. I bought one with larger capacity so I could keep adding to them that go back 12 years. you know, and someone looking for something on my phone who looks at every single picture will discover a great deal about my life, and I think that's true of most people. So, but there's no limit. If you say, I'm looking for whether they purchased an illegal, purchased something and didn't pay tax on it, so now I get to search every photo on their phone, then we don't have any real protection at all, do we?
So the key about everyday life in the phone from Riley was the police need a search warrant to search the phone, and that's what they did here. It's not a case where there's no limitation. The limitation was they could look through the photos to determine whether the evidence or the photos we think that category fits the category that's authorized them to seize as evidence. And we think that process, if they see something else that's not authorized by the search warrant, that's plenty of exception. The police, even in a physical search, does the same thing. They go into a house not knowing where the evidence might be, but they could search every single drawer that
They can't read it, right? They can't, I mean, obviously it depends what it is. But in general, it's not like, guys, let's settle in here for a week. There's 20 filing cabinets. We know what we're looking for. I'm going to read the full text of every document. Presumably, the second moment that they see it's nothing to do with it, they're not supposed to read the rest of it.
I think it depends on what the search warrant authorized. If the search warrant authorized communications, that leads to a screenshot of communications. At that point, the police needs to read the screenshots or communications. We think the photos to confirm or dispel whether that fit the categories of the search warrant. And in this case, the partially nude photo was the victims in a bathing suit. That does not require any extra reading. The police could just see it and confirm that that's being used, that could be used to hack into the victim's accounts. That's why it's being authorized by the search warrant, and it did not.
It says data related to. It doesn't mention including all photographs and documents or all IMG files or JPEG files. It's not. It just says data related to. Do you think, given the sensitivity of what's being searched for, that it ought to have requested something that indicated to the judge, you're allowing me to look at every photo and every document on this phone?
So the photograph is not authorized by the data category. It's authorized by another category called communication history, because there's history of communication. And
you're disclaiming reliance on D with respect to photographs.
No, I'm saying both. They could search
Well, that's not what you're
the photos and they can seize the photo. It's because it fits a category that it's data related to manipulation software.
So any search of a phone, right, you can take a screenshot of anything, right? Maybe you do, maybe you don't. I have no idea. I don't know what people take screenshots of. So anytime I'm looking for anything on a phone, a history of something, what was their search history? Well, that comes up in a lot of cases. Did they search for something about killing someone or drowning someone, or like whatever? So obviously there are quite routine ways of looking through someone's, for example, Google search history. I'm guessing with ChatGPT there is too. But you could take a screenshot of something, and now you can search through any photo as well?
No. The reason why the police look at photos was because no under SJC. The SJC recognized if you have probable cause to search communications, you can search photos because people take screenshots of your communication.
Why is search history any different? Oh, I search, how do you drown someone? And now it comes up on the Google search. The first hit is an ad for drowning equipment, but the second one that's not sponsored is real information. All right, I click, it shows some pictures and stuff, I take a screenshot. I may need that later.
The difference between a search history and communication is because search history is not authorized by the SJC at this moment. And I don't know if that's a step where the SJC or this court will move forward. But as for now, for this case, the SJC authorized a search of photos because of communication. And lastly, the sentencing issue. The original sentence, 7 to 9 years, was proper because the judge did not consider victims outside of the indictments. If you can see Record Appendix 111, that's out of the next case, 25P607, in the September 26, 2023 order, where the judge denied the initial, the only motion to revise revoke, the judge wrote, he did not consider any, quote, alleged uncharged conduct involved individuals other than the victim's name in the indictments. That order is clear. The judge was considered a sentencing proper.
That's a post hoc explanation. If you read the actual text, it seems ambiguous, doesn't it, about whether he's including the 400?
I disagree, because the judge did use the word the victims in this case, and she said, but 8. The but focus on he only recognized 8. And he did recognize the Commonwealth raised additional victims that's uncharged, but the judge's statement during that sentencing was clear. And even if not clear, his order, he was the trial judge who sentenced the defendant in this case. And this motion to revise revoke denial only came a few months after the sentencing. That statement, this court should take it and then to treat that the judge imposed the initial sentence properly. As to the lack of remorse, that did not come from the silence, which is a circuit split issue in federal court. The lack of remorse came from the defendant's own sentencing statement or argument where he admitted to the crimes, but only then he blamed his crimes on everyone else but himself. That is not a Fifth Amendment violation or issues that this court or the Federal Court of Appeals would concern. This is a case where the defendant volunteered statements that show lack of remorse. The judge properly considered that in his sentencing. However, 1.5 years later, the motion, who was also the trial judge.
Okay, so now you're at about 2 minutes. Why don't we see how long this goes for, and then we'll let your friend have the same amount of time.
Yes, Your Honor, and this will be brief. The motion judge, who was also the trial judge, abused his discretion and broke separation of powers when he modified and reduced the defendant's sentence 1.5 years later when he imposed the initial sentence. That 60-day limit is absolute. The judge even recognized in his...
The limit is for whenever you can file it, right? Filing the motion.
Yes.
And there was a motion filed.
Yes.
So what do we do with the motion to reconsider?
So it was not even filed. It was denied.
Construed it. You saw his reasoning, right? The judge construed all of these individual filings as really, nothing wrong with that. The judge can say, listen, this person's pro se, he's got a complaint about this, I'm going to take it as a motion for reconsideration.
I have two responses for that. Number one, a pro se defense treated as attorney in terms of the rules apply exactly the same, and this court does the same thing, even in appellate arguments and appellate briefing. If this court allowed a judge to treat any random filing motions unrelated to a motion to revise revoke as a motion to reconsider, then Rule 29's 60-day limit has no teeth whatsoever.
Well, the judge said each of these raised an objection to his sentencing. I mean, I'm not sure we have them in our, do we have them in the record?
Excuse me?
Do we have these filings within the 30 days? Do we have them?
I did not include it in the record appendix. I'm happy to file a supplemental one. But none of these papers were about the motion to revise revoke. It was about the motion for new trial for a different venue and to disqualify the original prosecutor on the case. It was letters about docket in that motion. None of these post-conviction papers had anything to do with the motion to revise revoke.
So are you saying there are additional things that were filed that we don't have in the record appendix?
My apologies. I'm sorry for that.
Because we have some of the letters, and we have the motion for new trial.
I included, so the papers were filed after the initial denial was a motion to a new trial in October 2023, motion denied in March 2024. So I apologize. I actually included everything in the record appendix.
We have everything, the
Yes,
October letter, the April letter, those are the things that he filed.
Yes, so my apologies. I modified my answer. I included every single paper file, including the transcript from handwritten to typing for the court's convenience. But every paper that was filed by the defendant was included in the Commonwealth Record Appendix.
Your argument is that the judge abused his discretion in construing these papers as a motion to reconsider? Is that what you're arguing?
Yes.
I didn't see that in your brief.
So that's the same point I raised, is the only way for the judge to properly allow the motion to rise and revoke in this case is to treat somehow these motions as a continuance or reconsideration. Otherwise, it violates the 60-day limit. That's absolute here. So the argument is very simple. The only way for the defendant to revise and revoke a sentence is to file a proper motion within 60 days of his sentence.
And
that
how
did
do
not
you
happen
respond to the your opponent's argument that the Commonwealth didn't object to the judge treating this as a motion to reconsider?
We did file a motion to reconsider, and that's an objection we made, and that properly preserved the issue. It was
At the hearing, the judge made clear he was treating these filings as a motion to reconsider, and there was no objection from the Commonwealth.
At the time, initial hearing, yes. It was.
Why isn't that waived then, when the judge made clear that's how he was construing these papers?
If the Commonwealth did not file a motion to reconsider, and I agree the issue would have been waived, but we did file a motion to reconsider, telling the judge that it was incorrect for him
And is this appeal, does this appeal include the motion to reconsider?
I believe so, but I'll double check. If not, I will certainly file a supplemental.
Okay.
Final point is, my friend on the other side said this is an academic issue. This is not academic in any way, because he cannot file a motion to reconsider or a motion to revise and revoke within 60 days after this court issued a risk writ, because the judge below has denied the defendant's motion to revise and revoke. He's stopped from filing another one. That issue has been addressed. The motion judge violated the Rule 29's absolute limit. This court has to. I encourage this court to vacate the judge's order and restore the initial sentence.
Just a question about what the judge actually considered.
Yes, Your Honor.
The judge justifies the change in sentence based on an assessment, and I believe states that the assessment doesn't take into consideration any new information post original sentencing information.
Right. So my friend is correct. I did not raise that issue below for different policy reasons within the office. I raised that for this court just to alert the court that this is not a one-off abuse of discretion. The judge not only violated Rule 29, he also violated the basics of motion to revise and revoke. You cannot consider any information that's not available at the time of sentencing. The judge recognized Bravo report was not available. That assessment was not available in 2023. He, however, considered that and revised the defendant's sentence, reduced it to 5 to 6 years. The defendant is now set to be released on January 25, 2026. So
I thought it was reduced by the minimum by 2 years, right? It went from 7 to 9 to 5 to 6?
Yes.
So you just said 6 years, but that, I think you
I
said
say he's
reduced by...
set to be released on January 25, 2026.
Okay. But that's 5 years or 6 years, or it's...
Because he had credits from this case.
Oh, I see. Okay. Thank you very much. Excellent, excellent argument. And we will hear again from your friend. And why don't we set the clock at 6 minutes, if we could.
So my brother referred to the threat that if this stands, any random filing could be taken to evade Rule 29. I'd submit this wasn't a random filing. I'm not... As I stand here, I can't put my finger on a particular page of the appendix. Mr. Hayes wrote voluminous letters to the court on a variety of issues, but he was constantly harping on the 7 to 9 year sentence.
If we review the filings and there's nothing about that 7 to 9 year sentence, is it fair to consider those filings?
If there is nothing at all, then yes, that would be a stretch. But again, I mean, the sentencing guidelines are 1 to 3 years, and I remember seeing that somewhere in there that this is multiple times that. As to the fourth point in my initial brief, I think I made this clear in a footnote, but Mr. Hayes is satisfied with the 5 to 6 year reduced sentence. Therefore, I'm not pressing that point. The only reason I kept that in the brief is because this other appeal came along and I wasn't sure the status of that.
So your position is if we affirm in this case, in the second case, we don't need to reach your fourth
Correct.
claim of error?
Correct.
Do you agree that the record appendix includes everything that the defendant sent?
I'm not prepared to agree to that, actually, because it's voluminous. It appears to, but I don't.
Because I have to say, the filings that were submitted in October of 2023,
Yes.
which were within 30 days of the denial of his motion, those don't make any reference to his sentence. The April 2024 letter does, but obviously that's not within 30 days, and I'm not saying that's jurisdictional, but
Right.
it came several months later.
It's true. I mean, I think the judge has discretion to consider a course of filings from a pro se client, and granted they're held to a similar standard, but to treat it as a motion to reconsider in this case. And
But this is all waivable, right?
This is, yeah, my primary argument is he said exactly what he's doing to the ADA, and she didn't say, you can't do that, it's too late, you know. And if she had, maybe, well, I don't know what he could have done, actually, but if she had done that, at least it would have alerted the issue. And
Well, but the judge was alerted to the issue on the motion for reconsideration, right?
That's true. As to the substance, I mean, I didn't quite understand what my brother said about, he seemed to say he agreed he waived the issue on the substantive consideration of the Bravo report, which is true, I think. I think it's doubly true because he didn't put it in the record, although maybe I waived the waiver argument because I put it in the record. But in any event, when you read it, it's 90% about pre-sentencing stuff. Admittedly, there's a little bit about classes he's taking in prison, but then the judge explicitly at the hearing and then again in the decision on the motion to reconsider said, I only considered the pre-sentencing related materials. There's no law that you can't.
An assessment that's done years later naturally takes into consideration information later.
Well, I think you can see where she did that because she talked specific. He took a class on Zen or something at prison, and you can see that's where she's considering the post-sentencing, and then most of it's biographical information and what he was doing and so on and so forth, which is completely appropriate. I cite a case in the reply brief where the SJC says this is the quintessential case where you get more information from the probation department about what should have been considered at the time of sentencing, and that's the whole purpose of it. And lastly, I'm not aware of any case actually that says you can't bring, that he's stopped from bringing a second motion to revise the sentence because the judge can, well, anyway, I cite a case where it happened. I don't know, there's clear law one way or the other, but it seems to me that if Mr. Hayes struck out in this court on both appeals, he actually, as I read Rule 29, could bring it again. Clearly, the judge who gave a very hard, he did give a harsh sentence, 7 to 9 years. I'm not belittling what the complainant and her family went through, but that's a harsh sentence, 7 to 9 years on an intimidation charge. And the judge thought the better of it, and he gave a 5 to 6 years, which is also a pretty serious sentence, but a more fair sentence, and that's clearly what he wanted to do. And this is sort of a piece with my appeal, which is like, what was he considering? So I submit that what he did here was proper.
I see no further questions. Thank you for a very excellent argument. Very interesting case. The two cases are submitted. Going, or you want a break? Or, no? Keep going or break? No, let's go one more. All right. The next case we will hear prior to taking our traditional mid-morning break is number 24833. This is Brossi versus Town of Grafton Planning Board. We will hear, if I can find the proper sheet, we will hear first from Attorney Grossman.
Thank you. If it please the court, Brian Grossman on behalf of David Brossi and Brigati Village LLC, the applicants for a proposed 57-unit multifamily development in the town of Grafton. This case comes down to one central issue: the planning board's arbitrary and capricious denial of a waiver from the limitation on dead-end roads to no longer than 500 feet. The sole basis on which the court articulated for upholding the denial of the waiver was the supposed risk associated to public safety related to emergency access. This finding by both the planning board and the land court is unsupported by any evidence in the record, contradicted by the expert testimony from Brigati's expert witness and the town's own fire chief, contradicted by the board's own undisturbed finding in its prior decision in 2019, the first decision on the application, and was also disavowed and backed away from by counsel and expressly rejected as a basis for its decision during trial when their predecessor counsel had a motion for directed verdict. Counsel expressly disclaimed that public safety was the basis for the board's decision, and that the only relevant consideration was the board's consideration of whether or not there was a conservation or public benefit. Despite both the land court and the town's position that this case solely hinges on the issue of the comparison to other subdivisions, that's inaccurate. And it would be a mistake to only look at the case that way. Our case is much stronger than that. Our case has 2 points. One, that when you look at the evidence in the record in the second trial, when you look at the finding expressly made by the board, the undisturbed finding made by the board that access in case of fire or catastrophe are adequate, that standing alone, even if you never get to the subdivision discussion at all, on the merits, the court made clear errors of law, clear error in findings of fact and errors of law. So the subdivisions are relevant because they give further support, but if the court were to decide that the subdivisions are not an apt comparison, that's not the end of our case. It doesn't decide
I mean,
the
there
matter.
are different legal standards that govern subdivisions versus the multifamilies, right? And the judge noted that. The judge specifically noted that in his decision.
There are, but that doesn't mean they're not relevant comparisons. They're different statutory structures to be sure, but of course the dead-end regulation itself and the waiver regulation that provides the authority for the board to grant the waiver come from the board's subdivision regulations.
But aren't the waivers encouraged for subdivisions versus and not for multifamilies?
They are, but that's not the be-all, end-all of the comparison, and I can explain why. The reason is when the cases that we cite talk about consistency. One of the things the board needs to be consistent about in its application is its application of reasons. That ultimately you could get to the same place and say, okay, if something's a conservation benefit, because it's a major residential subdivision or it's a multifamily, it's a conservation benefit. The preservation of trees, the lack of massive grading or something like that, that's a conservation benefit. When you get to the end analysis, whether or not that is more heavily weighted as a benefit toward granting the waiver, may be more tilted toward granting the waiver for a residential subdivision because of that encouragement. However, from applying the rules and regulations consistently, it would be arbitrary to say, well, this is not a benefit at all related to, just simply because it's related to multifamily residential and we're not encouraged to grant the waiver. The preservation of vegetation or the reducing of asphalt or the reducing of negative environmental effects, either way, from a consistency standpoint in terms of the consistent application of the rules, should be treated the same. When they get to the final end...
If the weight given to the factors is different, it's hard for me to see how it'd be arbitrary to treat the ultimate question differently.
The difference is the way they've done it here. It's in a number of instances, first of all, in a number of instances, as the court cited in its decision, they gave no reason. Literally none.
Isn't that okay? That's the fundamental problem I'm having with this case, to be honest. The case law seems to say they don't really have to give any reason, which is sort of what happened in the 2019 decision, right?
Right.
So then the judge says, well, you don't have to give reasons, but you do have to explain why you treated this one previous waiver differently, the Hillview Estates, right? So it goes back, and then they issue this remand decision, and they give several explanations why that was different. And it seems to me those, under our standard of review, those are adequate reasons to distinguish the prior waiver. And then they went on and said a bunch of other things that were wrong. So it seems that they didn't have to say anything, but they said too much. So what do we do in that situation?
It's not that they don't have to say anything. Remember, the standard is whether or not it's arbitrary or capricious. So there needs to be some, even if they exercise, first of all, if they exercise that discretion, right? Just to simply say, well, it's our discretion, we don't have to give a reason, then there would never be a successful zoning appeal under Section 17. If they don't have to give a reason.
I'm looking at Davis. Even when a board cites no reasons or any specific evidence for its denial, its action will be upheld as long as we can glean some sort of rational basis from the record.
But there is no rational basis.
Rational basis being we just don't want to grant the waiver because it's an unusual event, and here the benefits don't warrant granting the waiver. That's within their authority, right?
But if they're going to exercise that discretion, they still need to have actually said that that's what they were doing, and that's not what they did. What they did was they gave a reason, and that reason's bad. So they're not allowed to be arbitrary, they're not allowed to be capricious, they're not allowed to be whimsical. If they are going to set forth a reason, that reason needs to be supported. Otherwise, again, if they don't have to set forth any reason whatsoever, or can be let off the hook even if no one can figure out a reason, then that's just the definition of arbitrary. You have no applicant could ever be successful if they were denied, and that's not true. We know that's not true. There are plenty of cases where applicants have prevailed over boards and zoning boards of appeals.
As long as they treat everyone the same, that's not arbitrary, right? They can just, this particular composition of the board, they don't want to grant any of these waivers, and as long as they deny it to everyone, that would be okay, right?
No, I don't think so. They still would need to support their decisions. There still needs to be a valid reason. And if they're going to just cite their discretion, that's still something they actually need to cite to. This argument that they are solely acting under their discretion and that's why they did it, that is a brand new argument. That was not the reason advanced at trial.
Also,
and so it's not even something the court needs to consider here.
I don't really understand how that can be. We don't like these. That's not a rational reason that you can review for arbitrariness. We don't like these because we don't want any multifamily units in our town. Are they allowed to do that? I have no idea, but the zoning bylaws seem to permit multifamily uses, and all they've objected to is lengthening the road. If you could make a loop, which I guess you can't in this case, then we wouldn't even be here, maybe. I don't know why, right, it's a 3-2 vote with no real explanation of this seemingly minor waiver compared to approving building this huge thing. If they said we don't do it because we totally hate this developer, we totally hate all developers, that's not a I mean, maybe it's permissible. I don't see how it can be.
Just to be clear, when I meant we don't like these, I was referring to the dead-end roads, not the actual multifamily developments. So,
Okay, but I think the same board is approving, I don't know how old your subdivisions are, and I to the extent Justice Shin suggested a different standard, that seems like a substantial argument to me. But is this same board in fact approving longer roads, or are they all old with different compositions?
In general, there's a number of, I mean, we cite 13 different subdivisions where they granted roads of various length. The most recent one was a 750-foot road that was granted in between the 2019 decision and the 2022 decision. And one of the reasons they gave, this is where I was talking about consistency, one of the reasons they gave there, this is the writings, one of the reasons they gave there was that there was no opposition from the fire chief. And in this instance, what they've said is, well, no opposition. That we're not going to consider that because it's not the same. It's not the same as support. And so again, from a consistent application of the standards and the regulations, if they are consistently looking at and taking into evidence and factoring into their decision certain factors, and then here with no explanation, they're saying, no, that's not good enough. That's the definition of arbitrary. If you look at their prior decisions and you look at this one, you can't discern why this one actually got denied.
Can I ask you about the Hillcrest comparison? Mm-hmm. Okay, so obviously that's 20 years ago. Things change, although we haven't been told what, but things do change. But didn't the judge, I don't know if these are factual findings, the judge is allowed to make factual findings in these appeals, right?
Yes.
I don't know if there was evidence taken or if it was based on the evidence. They say there is access from Providence Road to a bunch of these houses, even though they're within the thing because it's a short distance. And he says there's no fire hydrants there.
Right.
That's not a legitimate reason for anything. You can't in fact firefight from Providence Road. So the facts that underlie the purported distinctions, at least that fact, has been knocked out, right?
Right. I mean, that was one of the reasons the board advanced, and the court said, no, that's not factually accurate, and I find differently. And that was the testimony at trial, is that access was actually illusory. And we agreed. I mean, that was our argument, was that reason was not actually accurate. Again, in terms of the upholding of the decision, when you get to the facts and you look at the record is based, putting aside the subdivision, just based on the evidence at record, is whether or not there was their claim, the basis for upholding this decision is that there's a safety access problem. Finding 48 that they made in the 2019 decision as part of the special permit, not specifically directed to the waiver, was very specific, and it's uncontradicted, and it was a finding that the court found should be binding on, the court found the undisturbed findings from the 2019 decision were binding on them, and this one was undisturbed, is based on the findings stated within the decision. Ingress
what
and
does
egress.
Undisturbed mean? In 20, whatever, when the second one, they say it's not safe, so how is it undisturbed? Seems like they reversed themselves.
Exactly. Well, it was.
They didn't take any new evidence. Maybe that's arbitrary or impossible or impermissible, or we shouldn't rely on it. But they do seem to have disturbed that finding.
It was the findings that were uncontested in the first trial. So this finding was uncontested, and so it was based upon the findings stated within the decision: ingress and egress to the property and the proposed structures thereon, with particular reference to automotive and pedestrian safety, convenience, traffic flow, and control, and access in case of fire or catastrophe are adequate. They made that finding in 2019. In 2022, taking no new evidence whatsoever, with no change in the project whatsoever, they suddenly decide that access to the property is inadequate for the granting of a waiver. You can't have both. You cannot have this finding and also in the same breath then say access is inadequate for us to grant the waiver because of public safety. There could be another reason they could have denied it, but that's not the reason they chose, and the reason they chose is unsupported by their own factual finding. Was, as I mentioned off the top, backed away from, it was disavowed by their counsel at trial. And then also contrary to the facts from the expert testimony and the testimony of their own fire chief. The access here is adequate. The length of the road...
Testimony of the fire chief?
Correct.
I thought the fire chief was part of a planning board thing that said don't build it on whatever street with the slope. At the curve, build it where it's now built. And then I thought there was, by law, comment has to be sought from the fire department, and none was made. So I don't really understand what fire chief we're talking about.
So the fire chief that originally commented on the project, I think he retired. He left Grafton for whatever reason. The fire chief that testified at trial, Chief Matthew, was the fire chief, I think still current fire chief for the town of Grafton. Town of Grafton put him on as a witness to help bolster their claims that access is inadequate, except under questioning, he said, fire will get there. And the testimony at trial was that under the NFPA, the road meets the town standards, meets NFPA standards, that NFPA doesn't look at length of road, it looks at the number of units, and the number of units here is treated the same as even Brigham at 26. So all of the different aspects that go towards safety, all the testimony that went towards safety demonstrated that access was adequate, and you just can't make a different finding and have it be supported on the record that was before the court.
So in the first appeal from the 2019 decision, you raised, I don't know if it was you personally, but your client raised two arguments. One was that the dead-end streets regulation just simply didn't apply, and the judge disagreed on that. That's no longer at issue, right?
Correct.
And then the second argument was that the board strayed from its precedent in denying this waiver when it had granted waivers in previous cases, and the judge said, all right, that holds some water with respect to this one, Hillview Estates, and then remands for the board to explain why they granted the waiver in Hillview Estates. So it goes back on remand, and let's say all the board did was explain why Hillview Estates was different, and that was the remand decision. Then we would affirm that, right? The problem is they said all these other things. I mean, from the 2019 decision, your client didn't argue that they were required to provide some further explanation as to why they denied the waiver.
Well, they didn't provide any explanation for the waiver. So the argument was two. One, that they didn't provide any explanation, and when you look at other comparable subdivisions,
Correct.
The explanation or the implied explanation is incorrect or doesn't hold water. But it wasn't solely that, again, and certainly not our position here, that the only relevant discussion point here is the subdivision, is the comparison to other subdivisions. It is the whether or not, on the basis of the evidence at trial, there was any support for the rational conclusion that access was problematic.
Your time has expired, but if there are more questions, I see none. Thank you for a great argument.
Thank you.
We will hear next from, I should really know who we'll hear next from. Let's find out. We will hear next from, I'm going to say Attorney Riley.
Yes.
All right, it worked.
Good morning, Your Honors. May it please the Court, Anthony Riley for the Grafton Planning Board. This morning we're here to ask the Court to affirm the Land Court's decision to uphold the Grafton Planning Board's decision to deny the applicant's special permit application. As you know, at the center of this case is the waiver of the 500-foot roadway requirement. And I think it's important to actually look at what the relevant waiver provision says. What I'm hearing from my brother is it seems to be flipping the burden on the board when it's really the applicant's burden to demonstrate things. So the waiver provision says if any waiver request regarding this provision shall require the board to specify the particular public and/or conservation benefit to be realized. That only requires the board to make findings if they choose to grant the waiver, which in this case they never did, whether it's the most recent matter under appeal or the original 2019 case. It does not say that if the applicant demonstrates a conservation benefit or other public benefit, then the board shall grant a waiver. like all normal waiver cases, the board has...
Do you have absolute discretion? Is that what you're saying?
I think the board has considerable discretion.
Absolute?
No, not absolute.
If it's
Cannot
not
be arbitrary or
absolute,
capricious.
then a reviewing court has to look at it to determine if it's arbitrary or capricious beyond the scope of your discretion. If it's not absolute, don't you have to explain why you did it so that they can say, oh yeah, that's not insane-o. You know, we rolled some dice and we agreed that if it was higher than 3, we would deny it. And the judge would say, that sounds arbitrary.
That's correct, and I think the second part of that is that the board only needs to state one valid reason for its decision. And in this case, and as the land court judge agreed, that the road length as compared to the emergency access and as compared to the Hillview Estates previous approval from 20 years prior was a valid reason why they could deny the road length.
Say that again. Could you, I'm having trouble, so the board doesn't have to state reasons, but we have to determine if there's a rational basis for the denial. And I'm frankly having a lot of trouble even seeing what the reason is. So could you just tell me what do you think is the reason they denied the waiver?
So in the board's decision, in finding F5, they state a couple reasons. Some better than others, but initially, you know, they acknowledge that the board is different now than it was in 2003. The plan is not the same as the previous Hillview Estates plan. The road length.
Let's put aside Hillview Estate. Okay, just putting that aside, what is the reason they denied the waiver?
For the safety reasons of extending the road further and emergency
Safety
access.
reasons. So then how do you get around the finding in the 2019 decision that there are no safety concerns?
It's a difficult question to answer. I think that's the basis of, and I know you said put aside Hillview, but it kind of all interplays because this is what the entire conversation is about. But I think, you know, when the argument is you need to give us the waiver because you gave the waiver to Hillview in 2003, the land court judge, when he remanded the original case, said you have to explain why these two things are different.
That's what's confusing to me, is that the board seemed to have said more than what the board was asking for on remand. But let's take the 2019 decision. So let's put aside Hillview Estates. In the 2019 decision, they found that there was a benefit and there are no safety concerns. And then they said waiver denied.
Correct.
So what's the reason?
In 2019, they didn't state one. That's why I got remanded.
But isn't that the relevant question? Not can you make something up in 2021 or whenever it was? I don't know what year the second one was. What was the reason you did this? The denial was in 2019. And so the question is, what was the reason? And on remand, they say safety. And then we look at 2019, or safety and no benefit or whatever, maybe both, I don't know. Then we look at 2019 and there's an express finding contemporaneous with the vote issued in the order denying it that says no safety concerns, good conservation benefit. So those couldn't have been the reasons it was denied in 2019, could they?
I think respectfully, I just think we're stuck with what the 2019 decision says and the first land court decision says. I wasn't counsel back then for them, so I just have the papers like the rest of us do. But I think this kind of ties into the point about discretion. Even if the applicant demonstrates safety and demonstrates some type of public or conservation benefit, they can still deny the roadway length waiver because the rule is roads can't be longer than 500 feet. And these roads are substantially longer.
So they have absolute discretion not to waive.
I have a hard time characterizing it as absolute, but I think when you have a rule they're allowed to stick to their rule. I understand.
That's the same as absolute discretion
Sure, then
not to deny.
I guess I would say yes, and there is absolute discretion, because otherwise, the burden would be flipped to the board, that if an applicant demonstrated what they needed to demonstrate, then the board would have to grant the waiver. Otherwise, then any applicant could just appeal every waiver
Well, as
denial.
long as it's not an arbitrary reason, you can. But you can't arbitrarily, right? Because we know arbitrary and capricious is no good.
Yeah, but I think the fact in of itself that the rule is 500 feet, and they want basically two roads that are substantially longer, that's a reason.
So so the board could take a position of never, we won't grant waivers, and that would be fine.
Sure, and that's not the case in Grafton, but in other
Okay, if
communities,
it's
that's how
not
they
the
operate.
case, if it's not the case that we just have a rule and we're going to stick with it, you're saying now that's not what's going on there. Don't we need to know why sometimes they say yes and sometimes they say no, so that we can avoid hatred or local nonsense being the actual reason? Or they suggest wanting to force them to file a new application under a law that now requires low-income housing when they filed their application days before that became the law.
Yeah, and I think it's fair to look at other decisions, but I think in this case the land court was correct, where you look at a similar type project. So, and in the land court's decision in footnote 2, he explains that this is a special permit case, this is not a subdivision case, the standards are different, the boards actually have more discretion.
But the judge also says, look, I don't buy this difference between, I guess Hillview, not Hillcrest. I don't buy this distinction between that you made between Hillview and the current one. There's no hydrants where you say there's going to be firefighting ability, and so I'm rejecting that, but you can change your mind after 20 years, and the judge almost says, and you have absolute discretion anyway. Actually, that's the way I read it, but maybe not. But change after 20 years, of course that's fine, so long as you have a reason that's not arbitrary.
It is true that the land court went page after page criticizing the inconsistencies in the decisions. Understood. But again, you only need to find one reason, and he did find one key difference between this project and Hillview Estates, and it was the length of the road. So there is a difference between this project and the 2003 approval.
But isn't it?
I read the judge to be saying that the board is entitled to weigh the benefits conferred by the project against what is an inherent safety risk posed by dead-end roads. And there's always going to be some risk, and decide whether the benefit outweighs that risk. That's what I read the judge to be saying. Can that reasonably be gleaned from the board's decision? I mean, it seems as though he is coming up with a rationale that is not stated in the board's decision. Because we're reviewing both. We're reviewing the judge's decision and the board's decision, right?
Right.
It's a little bit convoluted. I mean, that's not a factual finding, right? That's a legal determination?
Yeah, so I think that goes into the board's decision-making, is that so long as there's a demonstrated benefit, you have to weigh that against this, the safety configurations and the access of the road.
We have to be able to reasonably say that that was the basis for the board's decision, right? We can't just conjure it up on our own.
That's true.
Okay.
And you have to take the board's conclusions and apply the facts found by the judge against it to see if it all is consistent.
They never said it doesn't balance. They said there is no benefit and inadequate safety.
Right.
They didn't say there's this conservation benefit and also there's 57 new units for housing and whatever the value of that is. They didn't say, but this safety concern outweighs it.
Right, they said there
They
was
said
no
there's
benefit.
no benefit when they said there was a benefit.
That is
I
what
mean,
they
I know
said.
you have a tough time having to defend these opposites, but
That is what they said. I think I would just say that, and I know I've gone back to it a couple times, but even the land court's decision kind of shows how strong the discretion of a planning board is in a case about waivers. The decision details the issues, but at the end of the day, this road is long. They don't have to grant the waiver.
it's about 60 feet longer than the longest. The other one is 928 or 72, and this is 1,028. 50 feet longer?
So there's two drives here. One is 926 feet. The other is 1,052 feet.
And I thought there was one approved previously, admittedly in a subdivision, but approved previously that was 900 and some odd feet.
That's right, and that's in the Hillview Estates decision.
Okay.
So the difference, and the difference here is the area of the emergency access road. In the Hillview Estates decision, the emergency access is 120 feet up the entranceway. Here, the emergency access is 473 feet, which is almost towards the end of the 500-foot.
And what evidence in the record shows that that's a fire safety difference that makes a difference?
Well,
I mean, did you bring in an expert
so
who
in the
said?
board's decision,
Yeah.
it mentions how in Hillview Estates, after the emergency access way, there's 26 units. In this application, there's 57 units after the emergency access road, and I think you can infer that, more units further down the road causes a larger safety concern than what was approved in 2003.
If
And that's what the land
if there
court-
were some evidence of that.
Sorry, I missed that.
If there were some evidence of that.
There,
I mean, can they just draw a conclusion, like no fire chief has said, we don't have any objection, but we think 57 is a big fire safety risk, much bigger than 26, without someone coming in and saying, by the way, 57 is much worse than 26.
Well, I think that flips the burden on the board. I think the applicant has the burden to show that 26 versus 57 is not a big deal. I don't think it's up to the board to, bring in its own evidence at the hearing of why they made that conclusion. It's ultimately the applicant's burden to demonstrate compliance with the bylaw and the regulations. So if the board's not satisfied with what they reviewed and, in comparison to what happened in 2003, I think it's fully within their discretion to make the decision that the longer road with the, almost more than double the units past the emergency access way poses a safety threat where they're allowed to deny the waiver.
You have 6 seconds remaining, I don't know.
I was waiting for it to count. If I can address very quickly the claim for bad faith.
Sure, very quickly.
Very quickly. So the other issue here is that the applicants basically accusing the board of having ulterior motives to deny this project. I don't think there's any evidence in the record of that. And
Was there a finding by the judge on this? Did the judge make a finding?
No.
Is it a question of fact?
No, I don't think, well, the judge ruled in the board's favor, so I think it would be hard to find that, there's no reason to make a finding that the board acted in bad faith when the judge affirmed the board's decision. And I'll just also add that board member testified in this case over the applicant's objection, and there was an opportunity there to ask him all kinds of questions about, the board and why they did what they did. Maybe there would have been some objections to those questions, but you had a board member on the stand and you didn't ask him about any ulterior motive, so I don't think the issue is waived, I just don't think there's any evidence to suggest.
Well, there's evidence of it, but maybe it's not strong enough. I mean, there is evidence of it. They came up with no good, different reason. They changed what they did, and it was all after this law was passed, and someone said to them, would you consider putting in, I don't remember who, someone said, would you consider putting in some affordable housing? I feel like it was a board member who asked a question about that, but I may be wrong.
I think that was at the initial board hearing, but that's not what the board based their decision on. I mean, and there was no finding of the land court that was.
No, I agree with that. Your time has expired, but if there's questions on anything? No, thank you very much. Excellent arguments from both sides. Complicated case. Thank you very much. We are going to take our traditional mid-morning break, and we'll return in 10 to 15 minutes to hear the final two cases.
Rise, please. Court is now in recess.
Welcome back. We are back in session. And the next case we will hear is number 2514, Layman versus MBTA, and we will hear first from Attorney Brown. At least I think so.
May it please the court, my name is Peter Brown. I represent the appellant. Mark Layman unfortunately knows very personally the dangers of a train operating through our Commonwealth's 53 train stations that contain these at-grade crossings. And what I mean by that is crossings where people can walk, run, and bike through the station. In our brief on page 12, we gave you a pictorial example of the stations that we're talking about and the warning at the time that the individual enters the crossing that this case is all about. Through the public rights doctrine, acting on behalf of all of us, this litigation and appeal is about ensuring the last and best final chance for an individual to save their own life at that particular point belongs to the individual citizen and not a governmental bureaucracy. All that a result in our favor does in this case is make the MBTA go through the same Section 139 process as everyone else. If it is safe for a train to operate through a station crossing without sounding the whistle, they merely request it, they go through that statutory process, and they obtain the approval. Our argument is that they simply can't do it on their own. We believe.
Okay, let's say you've persuaded me that whistles are absolutely the way to go, the only safe way to do it. And I have to say, I was at an on-grade crossing in Wellesley recently, and having read this, the train rang only a bell, right? And it's like, maybe a whistle would be better. Let's say you've persuaded me of that. The statute says or, and it's said it for 100 and something years. I know it used to have a thing that said each of them. I don't know why they took it out, but it still says or. And so far as I'm aware, or meant or in Shakespeare's time, when this was written, and every day since then. So it's nice that whistles are better, but you aren't coming here and saying the Constitution requires that it be done because people are being killed, and it's not come up due process, not equal protection, it's not something. You're not doing anything like that. You're just saying this or means and. How are we supposed to do that?
So, Your Honor, we focus on 5 arguments, and the plain text is obviously part of it, and it is obviously our biggest problem that we have to go and overcome. But we view what we do when we look at it and to say, how does the court do what you've asked? I want to answer the question directly. We view our case analogous to Anderson. And in Anderson, that's when they went and the SJC examined our Constitution, not a statute, but examined the Constitution that went to the core function of citizen petitions that affect how we go and operate our government and the level of taxation. This dealt with the first version of the millionaire's tax. And what the SJC did there is they came out and said, we have to look at the full scheme. We have to look at the full intent, the purpose. We have to avoid the absurd result. And they went and they overwrote the or that was clearly in that section and said, no, here or means and. It can only mean and, because otherwise it would defeat the very purpose of what that constitutional right was there to go and
What year
protect.
did they say bell or whistle? What year did they say bell or whistle?
Bell or whistle, so when we go to the legislative history, Your Honor, it was bell or whistle back in the mid-1800s to the 60s.
In the mid-1800s,
Yes.
they decided they were going to do something for safety because trains were just running people over, apparently. And so they said, they should really make some kind of noise, maybe a bell or a whistle. And that's what they wrote.
That's correct, Your Honor.
Okay, and you're saying of necessity, if you wanted safety, you wouldn't put bell in there. And I have no idea in 18-whatever what they knew about bells and whistles or what the whistles were like then or what the bells were like. It says 30-pound bell must be that they want it to be pretty loud so it'll enhance safety, I just don't see, I mean, I don't know what to say. It doesn't look to me like safety compels taking the word bell out of there.
Well, I don't think I could go and argue. I think that's a policy argument that safety compels. And we make that argument to the MBTA, but that's not appropriate for litigation or a mandamus case. I want to start with the context, and I focus very much on the Plymouth case, where it goes and says, even when you have clear language, we have to go and look beyond it. We have to go and put it in the statutory scheme, and we have to make the effort to go and harmonize the statute. So I want to go back to the 1800s. I want to go specific to the language of 138. Importantly, the last sentence of 138 specifically ties to 139. It ends by stating, this section shall not affect the authority conferred upon the department by the following section. Back in the 1800s, the next section was 139. In 1941, the 1800s version got codified into what is now known as 160. When you go back and look, you'll see currently there's a 138A, but that didn't come until 1967. I think the language in OR, Justice Rubin, is dealing with two things. One is that 138 specifically envisioned a situation where people might not want whistles to be sounded, and they might go in through the administrative process, go and get safety enhancements at the crossings, and be able to go and silence the whistle. Not the bell, just the whistle. I believe the OR language was not referring to a choice between sounding the bell or the whistle. I think it was drafting that was dealing with two scenarios. One, your standard premise of ringing the bell and blasting the whistle, which is your standard requirements under 138, or a situation where a 139 whistle ban was granted, and then you would be going and ringing the bell. I think that helps give it some context and some of the phrasing. The case that my sister cites to, the Commonwealth, I believe it's AC case, on page 15 of their brief, talks about or is disjunctive, or is a choice, unless the context shows otherwise. And we believe the context here does show otherwise. I think it's also important that the warning is about that crossing, and it's about 1,320 feet before the crossing, a quarter mile away. So we're talking about that audibility warning that's supposed to be given way back and affect the person at the crossing. We know from the Boyd case that was 616.2 feet and 6 seconds before the incident went and happened. The court in that case found, in our seminal train safety case in Massachusetts, that no, that could still prove a recklessness standard because you got to follow the statutory obligation to sound the whistle all the way back from the beginning, because a matter of feet can make a difference, a matter of second or a tenth of a second could be the difference of whether we save a life or we don't go and save a life. And within the scheme, I think what's extremely important is that you don't have a bell ban. You only have a whistle ban. And the reason is that it rejects, in our view, a literal reading of 138 where the bell and the whistle are synonymous and they're equal. They're not. They're not as a matter of common sense. They're not as a matter of the purpose of what the statute is meant to go and achieve. And the bell still rings even if you go and sound the whistle. We know from the home rule petitions, which is an equivalent of 139, that the legislature understood when you wanted to silence the whistle, you went and enhanced the safety at the crossings. You added active warning things. You had gates and lights that were going as people were coming, and you rang the bell. So it's not bell and whistle. It was always whistle and bell, or bell and safety enhancements. And those bills were put forward by legislatures of individual communities, supported by the entirety of the legislature, and signed by the governor. So in our view, that's how the statutory scheme works. It's a public safety purpose statute. The purpose is to provide that warning. As the SJC determined, That is the best way. It's a critical way to go and save that life at that crossing.
So I've just looked at 139. I mean, I looked at it before, but I looked at the details of it. They can require under 138 a bell or whistle, or it is required under 138.
No, they can forbid or regulate the
No.
sounding of whistles.
I understand, but I'm looking, let's start with 138. I'm trying to figure out if the implication of 138 is you must sound a whistle.
Yes.
So this says, every railroad corporation shall cause a bell and a whistle on each locomotive, and such a bell shall be rung, or at least 3 separate distinct blasts of whistle on a distance of 80 rods, blah, blah, blah. Okay. So there's an order, every place it talks about the bell or the whistle. Then 139 says, you can, all right, but that's what's required.
Yes.
But it may be that the railroad company, not wanting liability, decides to blow the whistle everywhere, right? So when 139 says, hey, you can forbid them from blowing a whistle, which it doesn't say in 138, it says they have to do one or the other, I don't see how that's inconsistent. Some railroad companies blowing whistles, and the people complain, maybe they should be blowing a whistle regardless of the complaints. That's, not that's a policy choice unless it's in here. And now they can seek to stop the railroad from using the whistle even though it wants to. I don't see how that's inconsistent with reading or to mean or. It doesn't compel the conclusion that they must have been required to do both.
Our reading of 138 is with the or. To me, it's more of, I don't love the wording. To me, it's more of the manner in which they're talking about giving the audibility warning. And it was a way of transitioning and explaining. In one sense, you ring the bell. In another sense, you go and blast a whistle, and dealing with the possibility that you might not be sounding the whistle because of 139. We do not view 138 as creating that alternative. We do cite to the Boyd language. We don't believe it's dicta. We believe that the SJC meant what it said. It wasn't a footnote, but it was footnote 13, and it said very declaratively what 138 means, and it means it requires to sound the whistle in a particular way. And in that case, which was again a very, very important case, both for tort liability and train safety overall, the MBTA and their railroad operator at the time, Amtrak, case was remanded for potential recklessness liability under 138. And Justice Rubin, we think 139 goes and does harmonize with 138. The argument we also made in our reply brief is that the MBTA, and my sister argues, that they're exempt from 139. They don't need to use 139. That language doesn't exist in the statute at all. It goes and applies to everybody. So
You have to file a petition under 139. I think what they're saying, you correct me if I'm wrong, is that's not a petition we file. It's a petition someone who doesn't want a whistle near their house or restaurant or whatever business files.
Or it's an entity such as the MBTA.
But it says it has to be shared with the railroad corporation, suggesting that perhaps the railroad corporation isn't who's filing the petition.
I understand, but there's also, in our case, there's the governmental entity, and then there's the private railroad corporation. Both of constitute railroad corporations under 160, but in today's day and age, we have MBTA and we have Keolis, or whoever the next commuter rail operator is going to be. I believe 139 is just going and referring to notice, but I do understand the language in the statute, and it could be inferred that typically you wouldn't expect to go and see it, but I think we're also turning logic on our head, which is why I go back to common sense. We've cited all of their public statements. We've cited all standard public safety, because I don't think back in the 1800s, go through today, we can fully understand, at least Mr. Layman can't, and I can't, a train safety a train operating entity or a governmental bureaucracy that is actively choosing to not go and sound the device in the way.
You've never heard of the government deciding that some group of constituents or some interest that has a lot of money should be under-regulated? You're not aware of any example of under-regulation of a business that's powerful?
I am, Your Honor, but I would go and subscribe that there's a process for them to go and do what I would argue is unnatural, right? That the sounding of that whistle, they've admitted, is a life-saving technique, and why you wouldn't do it through the way of 139 and the home rule petition of safety upgrades at the crossing, then get rid of the whistle, that to me sounds counterintuitive.
Okay. Your time has expired. I've actually dominated this. Do you have a question? Am I? No, neither of you? All right, thank you very much. Very good argument. I think we understand it.
Thank you for giving us the
And we will
opportunity to
hear
present.
next from, maybe I know who, Attorney Sage.
Good afternoon, Your Honors. Jennifer Sage on behalf of the MBTA. May it please the
Can you
Court-
pull the microphone closer to yourself?
Sure. Can you hear me now?
Yeah, that's great.
This case is not about the best chance to avoid a train. This case is not about policy or Mr. Layman's view of the statute. The narrow issue before this court is whether there is a clear and unequivocal duty to sound the whistle pursuant to the statute for the extraordinary relief of mandamus to apply.
Why don't you guys sound the whistle? You guys say it's the best thing. You've got all kinds of stuff. The whistle, that's going to protect people. Whistle. Why don't you blow the whistle?
The whistle is blown in certain circumstances.
Why don't you blow it at grade crossings where people are crossing all across Massachusetts?
I think the statute gives the discretion.
I didn't
to
ask
the-
you that. I asked you why. Yes, maybe it does give you the discretion, but you say the whistle's best.
The whistle is, it's not for the MBTA or this court or the plaintiff to say the whistle is best.
You've said the whistle is best.
Those have come under the context of, well, those statements are not resources for this court's statutory interpretation.
I agree with that, but
Those-
I'm still trying to find out why you don't blow the
And
whistle.
those statements, Your Honor, were made in a far different context. Those statements were made in scenarios where the railroad is required to sound the whistle by federal regulation. In quiet zones and whistle bans and home petition rules have forbid that sounding of the whistle. And in that context, the MBTA's officials have said horns do save lives. Horns saving lives is not, it's not mutually exclusive with, the bell can save lives too.
Yes, but the whistle's better. MBTA says so.
In that context where they're required to sound the horn.
No.
pursuant to federal
I'm
regulations.
guessing it's better everywhere because you say. Now, I understand you may have some countervailing thing. You've said quiet zones.
And I think that.
I don't know. They let the bell, but not the whistle. I don't know.
I don't think that that's this court's, when the statute, and going back to the statute, when the statute is unambiguous, it is not for this court to substitute its judgment for that of the legislature who gave and entrusted the MBTA with the discretion of whether to ring or
Yeah,
sound.
but obviously you can't abuse your discretion, so I'm just wondering why you don't blow the whistle everywhere. I guess you've said quiet zones? That means
So-
what, near a hospital?
Nope. There are, Section 139, for instance, my brother has alluded to. Section 139 permits the DPU authority to forbid whistles from sounding. And that statute is very consistent with the discretion.
I agree that it seems to be consistent with discretion,
That-
but why would you grant such a, well, you don't grant the petition, it's the,
No, the Department of Public Utilities and also the Federal Railroad Administration has jurisdiction over the quiet zones. And the railroad is a very heavily regulated industry. There's not a lot of things that MBTA chooses to and not chooses to do. It's very regulated by this statute, and that's what this court's focus should be. On this statute is the MBTA.
well, I agree with that. I'm just trying to figure out, you can blow the whistle everywhere.
the railroad could, but sometimes it's dangerous to blow the whistle in certain
Give an
circumstances.
example, at an at-grade crossing 80 rods away.
Yes.
I don't know what a rod is,
My
but
experience, there's been situations, coming into a MBTA railroad grade crossing, if there's pedestrian crossings, station cut-throughs, and if the railroad chooses to sound the horn, which is very alarming, in those stations coming in, pedestrians along the platforms can sometimes be alarmed and jump into the railroad track. In those
you
situations,
have an example of someone who jumped in front of a train because the whistle blew? Is that what you're...
I'm just giving you an example of situations that a whistle might be more dangerous. But again, that is not this court's prerogative in this case.
That may well be right. That may well be right.
Yes. So the statute is...
Can you be held liable in tort for not blowing the whistle?
I mean, certainly, it depends on the circumstances, but the Boyd case is a clear example where the railroad, there was a question of fact as to whether the railroad was reckless in not sounding the horn in pursuant to the statute amongst, other factors that the court has considered. And in that case, that there were sufficient facts and evidence to bring to the jury of reckless conduct.
But they didn't ring the bell either.
In the Boyd case, there's no mention of the bell.
Because it's not a crossing, which is where you have to do it, within 80 rods.
The Boyd case was at a public highway rail grade crossing. So the statute is plain and simple in the sense that it states bell shall be rung or whistle sounded. The ordinary customary use of the disjunctive or requires either the sounding of the whistle or ringing of the bell, not both. The statute needs no interpretation, and it is to be applied as written. The context and the purpose do not demand otherwise, and there's no authority in the Boyd case for a contrary conclusion. My brother's complaint can be distilled, and Justice Rubin's questioning goes to it, that whistle is the better choice and the bell must be the wrong choice. But to compel the whistle instead of the bell would be to substitute the court's judgment for that of the legislature, who has entrusted the MBTA with the discretion of making that decision. And it's well established that mandamus cannot be used to compel a discretionary act. And whereas here the statute is clear, the function of this judiciary is to apply the statute and not amend it. And for the same reasoning that mandamus fails, there's no clear and unequivocal duty to sound the horn, Mr. Layman also has no standing to bring this action. And whether, for the last point, whether the crossing is a public way has no relevance or in the adjudication of this action.
Do you think we can reach the we need to know their standing. Do you think we can look at the statute to determine whether they're standing, or we have to take the complaint which asserts that there's a duty and then go to the merits to look at the statute?
I think the public rights doctrine provides standing only if it is to compel a clear and unequivocal duty. Here, the statute alone, the plain language of the statute, does not state a clear-cut legal duty to sound the whistle, and thus Mr. Layman has no standing to bring this action. If there's no further questions, I rest on my brief and request that the court affirm the judgment of the Superior Court.
Thank you very much. Thank you both. Excellent arguments. The case is submitted, I'm supposed to say on the record. The next matter is the Department of Children and Families versus father. This is an impounded case, so we will not use anyone's name. We can say things like father, mother, and child. we have divided argument on the appellant's side, with, if I'm not mistaken, mother getting 7 minutes, father 5, and the child whose position is currently opposed to affirmance 3. Is that correct?
correct,
Is that
Your
how
Honor.
everyone understands it?
That's correct.
Okay, well then we will hear first from Attorney Penta.
Thank you, and good afternoon. May it please the court, my name is Attorney Michael Penter, and I represent the appellant mother, who requested this court vacate the order awarding the department unconditional permanent custody and remand with instructions for the judge or the parties under the judge's oversight to develop a reunification plan for the child's safe and orderly return back to her custody and care. Considering my limited time, while mother certainly does not concede her unfitness, especially if the right supports are in place, at a minimum, when the judge found DCF failed to make reasonable efforts towards reunification, the judge was obligated to exercise her authority to diminish the adverse consequences of the breach of that duty, and it was an abuse of discretion for her not to. Judges do not just adjudicate fitness and unfitness. They must also enter orders that are conducive to the child's best interest, which in this case was either a unification plan or remedial orders to address DCF's failed reasonable efforts. So even if the court affirms the finding of unfitness, mother contends that her unfitness is temporary and inextricably linked to the department's failed reasonable efforts.
So they're now reunified.
It's an ongoing case, Your Honor. There is a review and redetermination tentatively scheduled for November 25th, but there's been...
Tentatively scheduled? It's
it's tentatively scheduled because it's 2 months from now. I don't know.
Are they, but the child is now placed with the mother?
The child is still is back at the Walker facility. He's back in residential care.
He's in residential care?
Correct.
The supplemental appendix, I think, indicated, and I know there's a debate about its propriety, but it indicated, I think, that the child had been placed with the mother.
The department placed the child with mother, and the child has been then replaced back at Walker. So this has been an ongoing case.
Okay, so I don't know if this question has any relevance, but it might.
Sure.
You have this redetermination hearing coming up.
I wouldn't characterize it as a termination hearing because it's mother's review and redetermination.
Yes, but this thing from DCF says it was allowed. I will ask about that, but I gather that means what was allowed is to proceed with a trial on that.
Under review and redetermination, there's a threshold question.
Yes, a change of circumstance or something.
Yes, and that
right?
threshold question was met and the review and redetermination was scheduled.
So if we reverse and say, sorry, this finding of conclusion that there's unfitness can't stand, does that interfere with mother's ability to go forward with this petition?
Well,
and do you have a position on what we should do about that if it does?
My position is, Your Honor, is that the review and redetermination, and it's said tentatively only because sometimes they're scheduled and then they get continued. But what this court, to address the issues that are raised in these briefs, could certainly have a great impact on what happens at the review and redetermination.
It would have what kind of, you got to slow down a little bit, maybe move the mic closer.
Oh,
It
could have impact on what happens at the review. I think that is better. What happens at a review and redetermination, for example, if finality by the appeals court would certainly have much more of a thrust as to how the review and redetermination goes forward.
There could be no review and redetermination. If we were to vacate this decision, the case, you'd have to start over, right? The review and redetermination builds on the previous decision.
Correct.
So if we were to vacate this decision, you would have to start over. Everyone would have to start over, right?
Well, I think the thrust of our argument is that the judge was erred in not providing more remedial measures. And I think even if a review and redetermination were to start anew or to pick up where it left off, that the failure to address a blatant problem with the department's failure to exercise reasonable efforts has that impact. And so...
But I really don't understand your answer to Justice Shin's question. If we, and maybe you're not asking us to vacate the order of finding unfitness, but asking us to do something about the opinion issued by the judge. But if we were to vacate that order, wouldn't we be in a position where the Commonwealth has to bring a new, whatever it is, whatever kind of petition in a care and protection happens to get full custody?
So, legally...
And would your redetermination just be converted to that trial, or it's trickier than that?
Well, the end of review and redetermination is going to assess current fitness. So even what may have happened may be considered older evidence as opposed to more recent evidence.
Sure, but my recollection is that in a review and redetermination, the baseline is, I know the burden is still on the Commonwealth, but the baseline is we've already found unfitness, so then let's look at changes to see if that's been removed. Isn't that right?
These cases are fluid. That's the challenge of these cases, is they do have fluidity to them. So the review and redetermination is, again, it's an assessment of what has happened since the last adjudication.
But you are continuing to ask us, you're pressing this appeal regardless of its consequences on the redetermination, that is your client's own petition for redetermination and review, or other way?
Well, of course, because I still think there are some inherent problems. So review and redetermination, as this court pointed out, picks up where the last case left off, if you will. But if the last case was infested with inherent problems, whether it's the finding of unfitness or whether it was the underlying order despite the unfitness, that guidance to the court for review and redetermination could be consequential. And so this doesn't moot, I would suggest, because otherwise the statute becomes feckless. The parent's right to review determination and a parent's right to appeal can't coexist, if you will, and they do. The parents at this point can't concurrently pursue reunification while also pursuing an appeal of the underlying adjudication.
All right, so I need to understand what you're asking us to do. Let's say we conclude that the court's opinion is inadequate to properly support the conclusions reached in September. Do we vacate the decision and remand for proper findings of facts and conclusions of law if the judge has them? Do we vacate the underlying order because it hasn't been supported adequately? What are you asking us to do?
Well, what I was asking to do based on the original order, but what we're asking to do now, I suppose, if we're talking about any shift, is that vacating the underlying order, if it's unsupported by clear and convincing evidence of unfitness, then that can't be a proper starting point for a review and redetermination. And given that this case started out as essentially a lack of supervision case, and because of the child's disorders that were developed because of his countless, I can count them, there were 13 placements in 7 months that resulted in the need for therapeutic care, my client is cautious about that, and a reunification plan might be necessary. So while legally or statutorily or even constitutionally, a fit parent deserves custody of their child, we don't want a plan that's set up for failure, that there are needs to institute. So in other words...
Do you want DCF to have the temporary custody that it had prior to the order?
It would still have temporary custody under the underlying 72-hour hearing. What would happen is there would be a new trial or a review and redetermination. There may be old evidence put forward. We're not arguing that the evidence itself was. I was arguing on appeal that other than a few erroneous findings, that the evidence itself didn't add up to clear and convincing evidence of unfitness. Doesn't mean the testimony is stale, or the testimony can't be reconsidered, but it does become less important in a current assessment of fitness a year later. And I think that's always the inherent problem with the fluidity of the cases, because the needle does shift.
If we were to find that the court improperly relied on the document in the supplemental appendix, what is the relief?
Well, the ultimate relief we're requesting is that that this court vacate the finding of unfitness and the award of permanent custody to the department.
What if we can't tell if without this document, I know you say something about without the document, and they do too.
I think that, I'm sorry, Your Honor.
What if we can't tell whether without this document?
I think that answers the question.
It's kind of woven into things.
I think that answers the question, Your Honor, is that if you can't tell, then it probably was an improper consideration for the judge to consider, because the document itself is not admissible absolutely. It's subject to the rigors of evidentiary advocacy, meaning
no, it should be cross-examination about it, should be introduced at the trial, and so on.
And be subject to motions and eliminate to strike portions of it that aren't of statements of fact that are. I'm sorry.
The judge found in September of 2024 that the parents were unfit.
Correct.
You represent in your reply brief that she took it under advisement. That's not correct. She found that they were unfit in September, right after trial. So why are we not looking at the evidence at trial to determine whether that determination is supported?
If that's an error in my brief, it was taken under advisement at the conclusion of trial, then the decision, then there was a written order.
There was a written order in September 2024 that says the DCF met its burden by clearing convincing evidence to prove both parents unfit, and there are findings entered on the docket to that effect. So why would we not be looking at the evidence at trial to determine whether that's correct?
I didn't submit to the court doesn't look at the evidence that was admitted at trial. The judge relied on a document that was admitted post-trial in December of 2024.
But she made the determination in September.
But she didn't issue her findings, so we don't know what findings. She didn't. There was a case, I think, of citing the Department's v. Valentina. And in that case, the judge had made a very robust decision from the bench on the evidence and then issued her written findings. There's none of that in this case. The judge took it under advisement at the conclusion of trial, maybe about a month later.
Why can't we excise every finding that refers to Exhibit 22 and then decide whether there's sufficient evidence?
I would suggest to this court that that some of those findings are directly related to the support the finding of unfitness, and it's unable to determine how much the judge gave weight to those findings. I submit to this court that he gave sufficient weight, a significant weight, because it goes to the heart of the suggestion that my client is unfit, such as engaging in or inconsistence in therapy, not talking to or not contacting the therapist because she had the phone number, but she did not have it at the time of trial. Those are only things that came up post-trial in that letter. And so it was never subject to cross-examination. And if we look at, and there's even a different social worker than the one who testified at trial who submitted that letter. So it would be improper for a letter that the judge relied on in finding my client unfit that wasn't subject to the scrutinies and rigor of challenge by the opposing parties to accept that as a basis for finding her unfit.
Okay, your time has long expired, but this is complicated a little bit. Do you have more? No? Okay, thank you so much.
Thank you.
We will hear next from Attorney Duran.
Good afternoon, Your Honors. Colleen Duran, may it please the court. I'm representing the appellant father. And to continue along this conversation, I see this as a two-way track. We're looking at a decision that was made September 17, 2024, which is the reason we're all here. And there is something now that has been filed in the juvenile court and because of another removal, and that's something the parents are pursuing. If this court made a ruling as to vacate the decision and go back to the juvenile court, possibly it could be the decision that the cases are consolidated moving forward.
Do you understand why it's been reassigned to a different judge?
What's been reassigned?
I think this case. Am I mistaken? I thought in the docket that I saw today, it showed reassignment, or am I confused?
I apologize, Your Honor. I didn't see that docket. I received the update from my trial attorney that works on this case.
Okay.
Is the goal for the child still reunification, or is it now adoption?
At this time, it's still reunification to my knowledge because it's mother that filed, we were informed, the review and redetermination.
So if the goal is reunification, aren't there some sort of services that are offered towards that end? I mean, what is it that What kind of remedial order are we supposed to enter?
If I could go back to why we're here today, I see the ruling of the juvenile court judge, and that's in that September decision, is an abuse of discretion. It's twofold. One, this case initially is about a working mother and needed assistance with childcare. She's from another country, came to the United States. She's not familiar with all the customs and what goes on here. And her children was removed by her child by a big agency. But she had, she was working. And one thing that the Department of Children and Families is not always great with is working parents. This is a woman that had been in a job for 10 years, and in the findings, the judge did find it was commendable. One could argue that the fitness ruling was linked to the department's failure to put services in place for this family to prevent removal. And then two, the second part of the abuse of discretion, I see the juvenile judge found that the department had not achieved reasonable efforts to reunify this family. And the decision that that judge made on September 17, 2024, was to have this department, the ones that had not met their burden of reasonable efforts, put a letter together. That letter didn't involve the parents, and the judge had other avenues available to her. She could have had weekly meetings. She could have had more parties, the parents, and experts. And again, back with the services, there's in accordance with 29C, the judge had a lot of services at her disposal that she could have ordered, and they're clearly outlined in CMR 110.7. Respite care, daycare services with daycare vouchers.
That's my question. So this, until when this appeal was filed, the goal was adoption, right?
No, it was adoption. It was adoption at one point, but then it changed back to reunification.
But now the goal is reunification, and the child is placed with the mother. I guess now the child is back in Walker. How do we know what kind of services are being offered to her right now? And what kind of remedial order are we supposed to ask the judge to enter?
Well, the remedial orders, as I mentioned, because her big issue that started all of this was she's a working mother.
She's not getting any of these services, even though the goal is reunification?
My understanding is still the department has an active action plan with her, and it's still the same services of, meeting with the child, participating in therapy. They're really anxious to have family therapy with this family, and to see what other services she can work with on behalf of the child at his placement. Mother did complete a psychological evaluation. There was a lot of favorable comments from that, that mother has really endured coming from El Salvador.
When was this? This is post-trial?
This was post-trial, yes.
Okay.
And to go back to this case too, there were a lot of things, as we said, that mother, after the time of trial, did do. She was engaging in services, completed a parenting class, as mentioned, the parenting evaluation. The evaluator there recognized mother's significant strengths, such as coming to the United States, starting a new life, working hard. And the evaluator opined that mother could care for her child with the right supports, but that she needed that help. Another big issue in this case that was found at trial was that mother and father both speak Spanish. That's their primary language. They didn't receive an action plan in Spanish for almost a year. There's no other services that the department, did for them. They didn't have a backup DCF team that could speak in Spanish. So if their social worker wasn't there, they didn't have somebody they could go to. They didn't have providers that could speak Spanish. And when the initial removal occurred, they, I believe, just received the typical flyer. They didn't receive an outline of how this process works with the Department of Children and Family, what you need to do to achieve reunification. A lot of different steps that could have been in place along the way.
Okay, your time has expired, and I see no further questions.
Thank
you very
Honors.
much. We appreciate your argument.
Thank you.
We will hear next from Attorney McKenna.
Good afternoon, Your Honors. Attorney Kristen McKenna. I represent the child. I last saw him last night, and he's an adorable 8-year-old little boy who is currently at Walker. He has maintained the position that he wants to be in the care of his mother since the beginning of this case. Trial counsel did not file an appeal on behalf of my child client, and therefore I did not submit a brief in this case, Your Honor,
But we're letting you argue, so
which I really
please.
appreciate, Your Honor. And so what's egregious about this case from the department's position is that they didn't make reasonable efforts. This young child at 5 years old, who is now 8, came to the attention of the department because he was home alone. And he was home alone because his mom was working. And he was home alone because his brother had gone out. And so it started off as a supervision case, as my brother explained. And so at that point, the Department of Children and Families, even if it sought emergency custody in the juvenile court, could have put in services at that time to ensure that this child was supervised.
Can they provide babysitting services? Can they provide daycare? And can they
Yes.
provide babysitters overnight? Because it seems like this mother's job requires her to travel quite a distance to do construction. I don't know if she's back and forth every night. Maybe she is.
That is true, Your Honor. So he was of age to be in kindergarten, so that could have been arranged. After school care could have been arranged. She had a friend who was certainly willing to watch.
Well, we have no
things.
evidence about that in the record, though. She
I
says
think
she had a friend.
She testified to that, Your Honor. So that's in the record. And so what's upsetting about it as we moved forward is that the 13 placements did emotionally dysregulate my client, and that's the reason that he ended up at Walker. I'm so glad that he went to Walker, because at that point, Your Honor, he did engage in therapy. He was able to achieve regulation at that time, and he was ready to go home by June of 2024. In May of 2024, that's when the foster care review was held. Mom's services and all of the efforts that she has made were reviewed. That's when reunification was changed back as a goal for this family.
Wait, in May of 2024?
It was a foster care review. And the foster care review found that there had not been enough efforts to make sure that this child
But
could
when
return
did
home.
DCF change the goal from adoption to reunification?
After that foster care review, Your Honor. So February of 2024, they changed the goal to adoption. May of 2024, there was a foster care review. They recommended that there be a change back to reunification. So it was at the time of trial.
And when did DCF change it? Prior to trial or subsequent?
It should have been prior to trial. They should have had a PPC within that 6-week period.
But you don't know that they did that?
You know
I mean,
what?
I'll ask
I
your
don't have it off the top of my head,
friend.
Your Honor.
Can
I do not.
I have, your time is up, but and maybe we all are, but certainly I'm very interested in the child's position. Is it your position that we should reverse the finding of unfitness?
At this point, I think that they should Your Honor should vacate the finding of unfitness and return it for a transition plan with services. Certainly, there
Why
will be...
wouldn't we be returning it for a new trial? There was a petition for care and protection and permanent custody.
So basically, Your Honor, the lack of reasonable efforts was found. At that time, the judge had the discretion to make an order for remedial efforts. Underlying the permanent custody order is a temporary custody order, Your Honor. It wouldn't be wise to dismiss the entire care and protection at this point.
No, I understand that. I just don't, I'm just very confused. Maybe the mother was unfit at the time of the trial, and maybe it was supported by clear and convincing evidence because of her lack of insight into having done anything wrong by leaving a 5-year-old alone, that her unfitness would continue into the future after 2 years of all these programs. She still didn't acknowledge that. And let's leave the remedial part out of it. I'm interested in the unfitness determination. If we found that, should we affirm the unfitness determination? Is there some reason we shouldn't? I understand you didn't write a brief, but here you are. So what's the...
Right, Your Honor. So if you maintain the unfitness determination that she has a right to challenge now in November, fine. But also send it back for this remedial... I know that this is something that the judge could have made orders in regard to what should have been put in place for this family to reunify and to...
Does the child support the review and redetermination?
Yes, at this point, yes, because he wants to go back to his mother. Absolutely.
I'll ask again your friend, but do you know why he was placed with his mother after a finding that she was permanently unfit?
Because the judge certainly was urging the Department of Children and Families to look at reunification and to look at a plan, a thoughtful plan.
I asked if you knew why she was returned to the mother's care. I understand that at some point he was living with his mother.
He did return to his mother, Your Honor, and unfortunately another 51A was filed.
And say that last part?
Another 51A was filed, so at that time, another removal happened. Now he's back at Walker. But we are still in the same position that we need services to help this family heal, to help my client be able to return to his family. At 8 years old.
What is the scope of the issues that are going to be heard in November?
My understanding is, I haven't read the review and redetermination, Your Honor, but honestly, I would think that the mother would want the child returned to her care, that there should be services in place before that in order to have that happen.
Are there not services in place right now? The goal, you say, is reunification.
The goal is reunification.
And you're saying DCF continues to not provide anything for her, or anything adequate for her?
My client is receiving services because he's at Walker.
Of course.
What mom is receiving, I'm not aware of.
Is the review and redetermination to assess whether she is still unfit, or is it for the purposes of deciding what services are needed for reunification?
It would still be current fitness. It would
I'm sorry?
Current fitness at that time.
So, and in November,
Reasonable
the
efforts.
other judge to which the case has been reassigned is going to hear evidence and decide whether the mother is still unfit?
Yes.
Okay.
Is there more you want to tell us about the child's desire to go back?
He sees his mother. They are visiting, Your Honor. He just saw her on Wednesday. He had a great visit with her. He enjoys his visits with her. And he told me that he wants to return home.
And is it your understanding that he has some diagnosis that makes Walker an appropriate placement for him? Because I think we heard from someone that there was no clear reason aside from the disruption of every foster home he'd been placed in for his placement at Walker.
He doesn't have a serious mental illness, Your Honor, but because of his behavioral needs and because of his emotional dysregulation at the time, that's why he was placed there. And since then, he's been replaced there because this was a very appropriate placement for him. He felt comfortable there. So I'm glad that he's somewhere that he feels comfortable. They know him. They all, when I was meeting with him, the staff all knew him, knew his name.
Now, you've also said, or someone said, that he became dysregulated because of these 13 placements. But in fact, did he not, at the initial placement, demonstrate sexualized behaviors that led to the disruption of it, or did that not happen till later? There were a number of
placements, Your Honor, and the initial one was more about his behavior, not necessarily a sexualized behavior, I believe, because it was with his stepfather and his sister Haley, and then after that there were multiple placements, which would be disruptive to any child.
Sure.
Particularly at that age.
All right. Is there more for? Okay. Thank you very much. We really appreciate your making your client's position clear.
Thank you.
And coming in to argue. Thank you very much. We will hear next from, but you don't appear to be Kristen McKenna, so I'm going to guess you're Arjun Jaykumar. Is that right?
That is correct, Justice Rubin.
Okay. So for the department.
May it please the Court, Arjun Jaykumar, Assistant Attorney General on behalf of the Department of Children and Families. At the outset, I'd just like to say that the Department is prepared to argue the merits of this appeal, as well as to discuss the impact of the scheduled proceedings in juvenile court. I'll be guided by the Court's preference and questioning, of course, but our position, for what it's worth, is that this appeal is essentially soon to be mooted by one form of superseding opinion or another, and that a stay or continuance may well be appropriate at this time.
You haven't made a motion for a continuance or a stay, have you?
We have not, Your Honor. I must confess, I only found out about the juvenile court docket on Wednesday, and I made the decision not to file a motion. If this court is inclined to go in that direction, I'm happy to file a motion subsequent.
How does it moot anything if it's the basis from which the redetermination departs?
I would say, Your Honor, that the opinion that the juvenile court issues following trial will supersede the prior findings and conclusions, and so those will be the operative findings and conclusions in the case for the purpose of appellate review.
Wait, I'm sorry. Which findings have been superseded?
I was going to say that once, none as of today, Your Honor, but once the juvenile court goes forward with the trial for the review and redetermination, the findings and conclusions that emerge from that trial will be the operative findings and conclusions.
But isn't
in this case.
Doesn't that proceeding take the finding of permanent unfitness, in this case, as the starting point, and then look at whether anything's changed? Whereas if we were to vacate the order, for example, there would be no such finding. I'm not sure what it would be that they're redetermining if we vacated the determination. Do you understand how that would work?
Correct, Your Honor. If this court were to vacate, for example, the prior findings, I would agree that technically a review and redetermination seems impossible. I don't know if that would result in simply that trial being converted to a new trial in the merits. But ultimately, functionally, I think it would.
Would you currently petition for permanent DCF custody? Is that still the position of the department?
The department is continuing to seek permanent custody with the goal of reunification, the ultimate goal of reunification. That remains the department's position. I would say, Your Honor, just to clarify, I do not believe there was a prior finding of permanent unfitness, but of present unfitness at the time of trial.
Wait, I'm sorry. You were given permanent custody until the child is 18 or your goals are met.
That's correct, Your Honor.
Doesn't that mean that she's unfit and that her unfitness will continue into the future?
No, Your Honor, not as I understand it. And I defer to the court's knowledge of the law, of course, but my understanding is that a finding that, or holding that unfitness would continue indefinitely into the future would be to support, for example, a termination of parental rights. And that is not this case.
No,
this
I
case
agree.
was a finding of present unfitness.
Why do you need permanent custody in a case where the goal is reunification?
Your Honor, I would say that for the moment, I can't speak to what the department is going to see, the reasoning that the department might seek permanent custody or might not seek permanent custody at the review and redetermination hearing.
Why did you seek it at this? You filed a petition to no longer have temporary, but to have permanent. Why?
Well, Your Honor, at the time of trial, as I believe, Your Honors, the court has previously observed, the department's goal was adoption, and it changed post-trial on, I think this was asked before, the date was December 17, 2024, to reunification. So at the time of trial, the department, I believe, was seeking permanent custody because the goal remained at that point adoption, but it is no longer.
So let's say, just hypothetically, we were to agree with Mother that the evidence doesn't establish her unfitness by clear and convincing evidence, and we vacate the order. Is everything vacated, or can, at the review and redetermination hearing, can the second judge rely on the subsidiary findings in the original decision that were unchallenged on appeal?
I would say that is correct, Your Honor. That the findings and conclusions that have, that the conclusion of unfitness would be vacated, but I do not understand the parties to be asking that, all of the subsidiary findings, for example, be stricken and not available for consideration at the R&R. So I think that your second hypothetical is my understanding.
If we were to find that the judge improperly relied on facts not in evidence by relying on so-called Exhibit 22, I've never heard of admitting exhibits after trial and giving them the next number, but what do I know? So if we find that that reliance was improper and that we can't properly carve out each place it's cited and then review that, would we vacate the findings and conclusions and send it back for new findings and conclusions, or will we vacate the original order as inadequately supported in the decision issued in December?
That is a good question, Your Honor. I would say, first of all, and I hope to, at some point, take the opportunity to convince you that that is not what the court should find.
Sure.
To answer the question directly, I do think that if this court were to determine that there was improper reliance upon the December 17th status report and that it was impossible to disentangle the findings that were derived from the report from the rest of the court's findings, and that it were further impossible to strike the improper findings and conclude that that the trial court's just findings were sufficiently important.
It's a lot of findings.
If that were to
right,
happen,
I mean, striking two findings about what happened on a Thursday might not, it gets much harder when you've got, big chunks and just a citation.
If that were to happen, Your Honor, I think that the order, the notice of decision of September, I mean, if it were impossible for this court to find that that order could stand on its own without anything citing to Exhibit 22 or without anything clearly derived from Exhibit 22, yes, I think that order would have to be vacated, Your Honor.
Just the order, the December order, not the September order, and sent back for better explanation, fuller or proper explanation, or the whole thing is vacated?
I suppose that would depend on this court's view of the evidence. I think that the former would be a direction in which this court could go. If this court were to say, Cleveland Court Judge, you should not have cited to this exhibit in the record, why don't you go back and explain to us exactly, absent this exhibit, how your findings of fact support your conclusions of law? That is something this court could do. Alternatively, if this court views the evidence as, insufficient, taking those findings out to support the finding, then I mean that's
sure. If
I would disagree with that,
insufficient is different than properly, the findings is different from the evidence.
Do you know why it's going to a different judge?
I'm not aware of that, Your Honor.
So if we were to go with the option of vacating the later order and requiring new findings, that would go back to the original judge, right? At the same time that the second judge is holding the review and redetermination.
I suppose it would, Your Honor. So if I may, I'm happy to.
But you're not aware of any conflict or anything that, the current judge, if it went back, couldn't touch it?
No, Your Honor, I'm aware of no such conflict.
Or anything, some reason. I mean, it's now been transferred to two different judges. It seems odd to me, but.
I think it was, until fairly recently, and I believe this summer, it stayed with Judge Hardiman. I do not know why it has been transferred. I'm not aware of any conflict, which I do not mean to suggest that.
But you don't know at all why it was transferred?
I do not, Your Honor.
Okay.
I think there is, both for me and for my friends to my left, I think there is some disconnect between trial counsel and appellate counsel on all sides.
The fact that no party notified us about this until this morning does suggest that.
For which I apologize, Your Honor, and but I think that is unfortunately, the world we were in, and if I'd known a week ago, we may have a motion to stay, and we might be arguing something completely different, but.
Counsel, let me ask you about what the judge did in this case. On the one hand, finding unfitness, also finding a lack of reasonable efforts, which the two together seem incongruous. Do you take a position as to what the judge should have done?
I do, Your Honor. I think that the incongruity that you note, I think actually speaks to the trial court's careful weighing of the evidence. I think that it should undermine, any idea that, for example, the juvenile court had an agenda or was not, paying close attention to the testimony and carefully weighing the evidence. I think in this case, the juvenile court was able to weigh the evidence in such a way that the trial judge found both clear and convincing evidence of unfitness, but also that the department, for its part, had not done enough to specifically, and this is conclusion of Law 24, and it's in the notice of decision as well, to find an appropriate placement for a child post-Walker. And that was important because I think as the trial court found, the child was languishing at Walker. He'd been there for some time, made progress, and that the department had not, at that point, done enough to find an appropriate step-down placement. So I think that the incongruity really speaks to an ability to sift through the evidence and not sort of take a one-sided view of it, I think.
But is there any reason that the judge wouldn't go further and give direction as to what should be done?
I think that is actually embedded in conclusion of Law 24. I think the clear suggestion from the trial court was you need to find an appropriate placement post-Walker for this kid. And that is essentially the first step. The step down was the first remedial step that the trial court ordered. So, I disagree somewhat with actually quite a bit, with my friends on the other side, in that the trial court clearly did indicate what remedial steps it wanted DCF to make. It ordered in the September notice of decision, it stated, we're going to have a status hearing on December. I want you to submit a report saying exactly what you're doing to step this kid down. And in that report, I know maybe we should talk about whether it should be considered or admitted, but in that report, DCF responded by saying, we're going to keep him at Walker until we can put him at home. We think that the least disruptive thing would be not to take the intermediate step, but our goal is to eventually reunify him with mom. And we want him to go directly from Walker to mom's care.
So was it proper for the judge to consider the December report on that issue? On whether to enter a specific remedial order after she found that the department didn't make reasonable efforts?
I don't know that I would say that was considered as part of, I think that the trial courts, I don't know that it was part of what the trial court considered when discussing the remedial efforts that DCF should take. Again, conclusion of Law 24 says step him down to, or suggests that.
Right, and the December report says that's what they're doing.
Right.
Right, so when the judge issued her findings, she was aware now. I wasn't part of the reason why the judge found lack of reasonable efforts is because the department didn't have a plan for where the child was going to go after Walker. Wasn't that part of it?
That's right.
So now she has a report that says the department is making plans to transition him to a foster home from Walker. So that is something the judge could consider, isn't it, when not on the unfitness, but on whether a remedial order was necessary.
I see, Your Honor. I'm sorry, I misunderstood your question. Yes, I think that is correct. And that goes to, I think Justice Rubin had pointed this out earlier, which is when, or maybe it was you, Justice Shin, I'm sorry, but when part of the issue with being litigated is what remedial efforts have been taken, it's very difficult to disentangle sort of what was ordered at the time of trial. It's very difficult not to look at what remedial efforts are underway. And so that makes separating pretrial and post-trial a challenge.
You could hold a hearing.
I'm sorry?
If you're the judge, you could hold a hearing to see what's going on and figure out what's needed, I suppose.
And that's, that is what has continue to happen. That was what the December 17th hearing was about, in a sense, and as I understand it, subsequent hearings in the case.
Am I correct that the department's position could change? I mean, we've heard there's a 51A and the kid's back in Walker. Obviously, I don't know how serious or not that is, but there's nothing that prevents you right now. What's your position in the review and redetermination, or has it not been stated yet? That is, do you oppose it? Do you support it? Or we don't know?
Based on my discussions with my client, my understanding is that the department's goal remains reunification, that the department's position is that it should retain custody. Whether that's permanent custody, temporary custody, I am not currently in a position to say. And that, as Ms. McKenna stated, I think that the Walker placement is appropriate for now. That's the extent of what I know as to the department's position as of today. I wish I could say more.
Do you know more that you're not saying, or you mean you wish you knew more?
I wish I knew more, and I would be happy to share it with this court if I did.
Okay.
Again,
I mean, you don't have to, obviously. It may be litigation, other litigation related, right? I don't use
No, that's true. But I mean, that is what I understand the department's position to be as of now.
Just a question about, if the judge made a determination that there were not reasonable efforts, was an option to not make a final finding then and to continue the matter further? Would that have been an option?
I think it could have been an option, Your Honor, but again, as Mr. Penta stated in argument, the standard here is abuse of discretion. When it comes to equitable remedies within the trial court's power to issue, the trial court has a great deal of discretion to fashion what those remedies should be, or if there should be remedies at all. And so, yes, I would agree that that could have been an option, but I think the trial court indicated to the parties what it wanted DCF to do next, and that is clear within conclusion of Law 24 and within the notice of decision. And I do not think that, respectfully, that either of my friends have demonstrated that there was any abuse of discretion. If I may, I know I'm over time. I know I'm over time, so I would just like to, on the merits, I would like to address, I suppose, the issues that the court has the most skepticism about, whether that's how to disentangle Exhibit 22, whether that's, is there clear and convincing evidence of unfitness, whatever I think the court is most inclined to think I could lose on, I'd like to address.
Well, we haven't deliberated yet, so the court doesn't have any view on any of these questions. But you can make your affirmative case if you'd like for a few minutes, because we did let the other side go over probably total by about 5, no, maybe a little more, 7 minutes.
I'll do my best then, Your Honor, to keep it brief. This court should
and you should know your brief is excellent. I think we understand your arguments on the merits from that, but certainly.
Well, thank you, Your Honor. This court should affirm the judgment of the juvenile court that mother and father were, at the time of trial, presently unfit to parent child, and the permanent custody was awarded to the department. This judgment was supported by clear and convincing evidence of unfitness. Mother left child at home alone when he was 5, while she went to work hours away. Child informed the department this wasn't the first time that had happened. He'd also missed recommended medical care. Mom had failed to attend his medical appointments. He wasn't in school. Even 2 years later at trial, mother still had difficulty accepting responsibility for this very serious mistake. While child was in the department's custody, mother missed or was late to visits, medical appointments, and family therapy sessions. Sometimes that was because of work, but she also missed 5 scheduled medical appointments when she was on leave from work. And to be clear, Your Honors, as was referenced in my friend's argument, this is a child with significant needs. This is a kid who needed significant supports to control himself in a number of placements. The record demonstrates sexualized or hypersexualized behavior, frequent outbursts, 5 placements requested removal. Ultimately, the department's conclusion in trial, the trial court's conclusion was that this child needed someone trained, someone who knew how to deal with significant needs, and that mom wasn't there yet at that point. I do want to emphasize what the juvenile court's order doesn't do. It doesn't terminate the parental rights of either parent. It does not find that mother didn't complete several items on her action plan. And it did find that the department failed to make reasonable efforts toward reunification, which again, I think underscores the juvenile court's careful attention to the evidence. I would like to turn.
Can I just make a little comment, maybe something you could take back to DCF, maybe to the trial lawyers there.
I will write this down, Your Honor.
This child exhibited sexualized behaviors in their foster homes. We see an unfortunate amount of that. None of that is used as a basis for this order. I have no idea whether that is what the basis of that behavior is, but I would think DCF would have been a little more interested in figuring that out and telling us, right? Because if it's because of something that happened in the home, this reunification looks a lot different than if it isn't. And we have no idea. But obviously that conduct, it caught at least my attention. I also think putting on a social worker who can't tell us why the child is in family therapy, and then the judge, of course, says she missed some family therapy, and we literally have no idea why. I'm not saying it's inappropriate. I'm sure there is a reason, right? But we don't know what it is. I thought this actually was to put on a social worker who recently joined, who didn't know a million things. We're told by the judge that the older sibling has mental health issues and therefore was an inappropriate person to leave the child with, if the child was left with that person at all, of course. What mental health issues? What are we talking about? It's an adult. Are they unfit to be a babysitter? You know what I mean? It's just not like there's a bunch of evidence in obviously that supports a finding of unfitness, but I feel like we're left without the whole picture, and especially this thing where the children act out in ways that are grievous sometimes in foster care, and DCF doesn't tell us anything about why that might have happened, and that seems important to me, but so.
No, I appreciate that, Your Honor, and I think it is, again, the record in this case begins at the time of removal. I know there were prior incidents with other kids, but, the record in this case begins at the trial of removal, and so where sort of this came from, this type of behavior, is not in the record, and I agree that is something that seems relevant to placement, to the goal of reunification, and that, hopefully.
And termination and fitness, everything.
Absolutely. I agree, Your Honor, and I will.
And I'm not like berating you or them or whatever. I've seen this a bunch, and I feel like we need to know, we don't have the first idea what's actually going on. Because that seems like the most, obviously leaving the child alone is the way this happens, very big deal. But this is a big deal too, and it disrupts 13 placements.
Yeah.
I don't know.
Just to wrap up very quickly, Your Honors, I will turn to the December 17th report, which I do think is, I just want to make sure that I make my position clear. As Your Honors noted, it was not a preliminary or conditional decision. It was a final decision on September 18th. So I think one of the questions that the court has to ask, which is, would the outcome have been the same absent, if this December report had never been considered, I think is already answered. It would have been, because it was, the decision was made 3 months earlier.
Yeah, but that's backwards. To say, we don't care what the justifications are for that decision itself proves that there were justifications, is not how law works, right?
I thought you might ask that, Your Honor. And so I would say, if the court looks at the actual findings attributed to the status report and considers whether they could have reasonably been outcome determinative, or if this was some kind of ex post rationalization, I think, construing them carefully makes it pretty clear. First, 5 of them are helpful in one form or another to mother and father. They're saying, they're crediting them with visits or attendance family therapy sessions, or alternatively critical of the department, saying, as one of my friends pointed out, mom belatedly got a Spanish language copy of her action plan.
They're not all positive.
They're not all positive.
And they weren't introduced in evidence that,
I'd say, some of no, they were not all positive, but, two of them also concern, or not really related to unfitness. So a child gets an IEP, for example, after the trial, or a child starts taking medication after the trial. There are a host of findings that are not positive, but are cumulative of other evidence. And I think that, we cited to Luke as well as Valentina for the proposition that that kind of cumulative evidence is not particularly problematic. Those would be, mom didn't attend mental health services outside of the family therapy sessions that she did attend. That's well supported in the record elsewhere.
So we have your brief on this, and I think we understand the arguments pretty well.
So I won't gild the lily then. I won't paint the lily then. I will not paint the lily then.
Okay, that seems smart. Thank you very, very much. All of your arguments have been excellent. These are very hard cases for us, obviously, and among the most important that we hear. So we appreciate all the assistance that counsel gives us. With that, our sitting for today is at an end. The case is submitted, I should say, and now it's at an end. So the court stands, well, with thanks to the court staff and to the court officers, we will stand in recess.
Court all rise, please. Court is now in recess.